All right, good afternoon, everyone. I'm going to go ahead and mute and turn off my camera for a few minutes just so that we can get everybody in and situated. And so I see we have a number of people, but it looks like we're waiting on a few others as well. And the echo is because I had YouTube open. And then if I could get a couple of team members, at least one team member, to send a message to one of your other team members, just to make sure you're able to chat with one another privately.
Yeah, that's someone. It's yours. This is my comfy chair. This is my stress reliever chair.
So what do I need to put as my name? Oh.
All right, good afternoon, everyone. I know we were having one of the computers with feedback. Did you guys get that resolved? And then I think everybody was able to message, or the chat feature was working. So I don't see anybody waiting. Did the teams know of anyone else we're waiting for? And if everyone thinks we're good to go, give me a thumbs up. Perfect. Okay, I see we have our scoring judges here as well. So I'll just ask the scoring judges to go ahead and shut off their video cameras in a few minutes. But before that, why don't I have everybody turn on all of their cameras for some preliminary matters, and then I'll have you shut off your cameras as well. I did attempt to paste your rosters into the chat feature so the scoring judges could scroll through that if they needed to see your names, but I will have you all introduce yourselves. And so, first of all, I just want to confirm it doesn't appear that there are any video recorders present or being used. I don't believe we have any coaches who should not be here in the rooms, and so we are ready to go. As you know, this is being live streamed on YouTube for other people to view. I remind everybody that we don't have any recesses during this trial. The participants are aware of that. We've told the judges that as well. If there is some sort of emergency that arises, please get my attention and let me know. I know that at times a few team members have had situations with the internet or you've been dropped out of the meeting. If that occurs, if a team member notices, let us know right away and we'll make sure we stop the tournament and the time and address any technology issues and make sure we have all of your teams present. Likewise, if you're a scoring panelist and you happen to get dropped as well, either shoot me a text or an email so that we can stop until you all get back. I think the technology has been working fairly well, so I thank you all for your patience and your hard work in doing mock trial by video this year. And so with the understanding that we may have glitches, everyone will be patient and work through those. I'll ask each of the scoring panelists now that you're in the virtual courtroom, whether you see anybody or know anybody in such a manner that would cause you to believe that you may be biased for or against either of the teams in this round. Seeing the heads shaking no, it appears we are okay with regard to that. I remind the teams and coaches that any disputes arising out of the competition must be reported in accordance with the competition rules. You all are required to comply with the time requirements, and to the extent that those requirements are complied with or are not, you may consider that as scoring judges in terms of individual scoring performance. And so with that, I will allow the prosecution to introduce themselves and their witnesses. I'd ask that you make sure you have your names visible so that the scoring attorneys, scoring judges can see them. It appears that you all do. And so with that, who's introducing first on behalf of the prosecution?
That would be me, Your Honor.
Excellent.
Good afternoon. My name is Hannah Feeney. I will be delivering the opening statement, conducting the direct examination of Alex Cifuentes, and the cross-examination of Avery Becker.
Good afternoon. My name is Anna Carrington. I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Professor Blake Van Owen.
Good afternoon. My name is Annika Buchin. I will be conducting the direct examination of Kyle Kuzak, the cross-examination of Taylor Perkins, as well as presenting the closing argument. May our witnesses introduce themselves?
They may. Thank you, Ms. Buchin.
Good afternoon. My name is Grace Oliver, and I am Alex Cifuentes.
Good afternoon. My name is Kate Malloy, and I am Detective Jordan Markowitz.
Good afternoon. My name is Pilar Melendez, and I am Kyle Kuzak.
Thank you. And then on behalf of the defense?
Yes, Your Honor. My name is Bailey Braun. I will be conducting the opening statement for defense, as well as the cross-examination of Kyle Cusack and the direct examination of Taylor Perkins.
Good afternoon, Your Honor. I will be conducting the the director and the cross-examination of Alex Fuentes.
And what's your name?
Good afternoon. My name is Layla Moore, and I will be conducting the direct examination of Blake Van Owen, the cross-examination of Detective Markowitz, and the closing argument. May our witnesses introduce themselves?
They may. Thank you. And Mr. Loya, I don't think you said your name. Would you just tell the judges your name?
About that, excuse me. My name is Jair Loya.
Excellent. Thank you. All right. And then the witnesses.
Good afternoon, Your Honor, opposing counsel, ladies and gentlemen of the jury. My name is Mackenzie Cagle, and I am Taylor Perkins.
Good afternoon.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Eiley Rubio, and I am Professor Blake Van Owen.
Good afternoon, Your Honor, opposing counsel, ladies and gentlemen of the jury. My name is Dylan Pearson, and I am Avery Becker.
Excellent. Thank you all. Scoring panelists, were there any names that you did not get or would like repeated? Excellent. I have shut off the feature for the videos, and so the only thing you should see on the screen is people with active videos from this point forward. And so with that, I need to swear in team members and witnesses first, as well as members of the gallery and scoring panelists. And so let's go ahead and start with the team members. If all of you would raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes,
Yes,
Your
Your
Honor.
Your
Honor.
Honor.
And then witnesses, if you would raise your right hands. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your
Yes, Your
Honor.
Honor.
Thank you. Those of you who are gallery members who are watching from YouTube, including teacher coaches, I'd ask you to raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round?
Yes, Your Honor.
And then finally, to the scoring panelists, if you'd raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Yes, Judge.
Excellent. All right, for the scoring panelists, if I move on too fast at any point, please just make sure to let me know that you need more time to calculate your scores. And so with that, I will ask the teams if they have any preliminary matters that they would like to discuss, starting with the prosecution.
Yes, Your Honor.
Thank you, Ms. Feeney.
At this time, let the record reflect that the prosecution has put their roster and the pronouns of all of their witnesses in the chat.
Thank you. And so Ms. Feeney's indicated, I'm seeing this now, that the preferred pronouns for each of their witnesses are in the chat as well as their rosters if you need that. Thank you. Go ahead.
Before we begin, we would like to verify a few mechanisms of this online trial. Specifically, the prosecution will be admitting evidence pursuant to Rule 7.4 of the Rules of Competition. As such, any exhibit displayed on the screen will be assumed not to be seen by the jury unless we specifically ask to publish. And we will only ask to do so when we intend to show the exhibit to the jury following admission.
And so based upon the rules of the competition, the scoring panelists are instructed that for purposes of laying foundation and seeking the admission of exhibit, you may see it, but you're instructed that that is purely procedural and you are not to have been deemed to have seen an exhibit until it's moved for publication and I've authorized its publication. And then the scoring panelists can go ahead and shut their cameras off now. Sorry, go ahead, Ms. Feeney.
Yes, Your Honor. Furthermore, may we have permission to display exhibits as needed for purposes of admission, or would you like us to ask permission each time?
You're welcome to display an exhibit. I'll know that you're doing it since you'll have to ask someone to do that display for you, but thank you.
Yes, Your Honor. Also, may we have permission to zoom into or otherwise modify exhibits for purposes of clarity?
You may, to help the witness be able to see or for the jury to be able to see certain portions given the format that we're using.
Just to clarify, does the court intend to constructively read the jury instructions before or after closing argument?
I will constructively read them prior to closing argument.
And while all witnesses and attorneys have made efforts to be in a space with the best internet capabilities possible, if at any time you are unable to see or hear us, please feel free to interrupt us.
Thank you, Ms. Feeney. And I would make the same observation and give leave to the presiding, the scoring judges as well. If you are having technical issues either on your end or with the witness, please let us know.
Just to clarify, the witnesses are also going to be present for the entirety of the trial today, pursuant to Rule 5.3.1 of the Rules of Competition.
That is correct.
We reserve any remaining time from our closing argument for rebuttal.
Thank you.
And at this time, have the stipulations been constructively read into the record?
They have not. Would you like me to do so?
Yes, Your Honor.
And is there any objection to that from the defense?
No, Your Honor.
All right, the stipulations are accepted by the court, and I've constructively read them into the record, and so the presiding, I have to call them presiding judges, the scoring judges are now aware of them.
With that, I have no further preliminary matters.
Thank you, Ms. Feeney. And then Ms. Braun, did the defense have any preliminary matters?
We simply ask that anything granted to prosecution be granted to defense.
That request is granted.
Thank you, Your Honor.
All right, with that, I believe, Ms. Feeney, you indicated you were providing the opening on behalf of the prosecution. Is that correct?
Yes, Your Honor.
I'd invite you to do so now.
Before I begin, can Your Honor see and hear me all right?
I see you clearly and your sound is perfect.
May it please the court?
It may, thank you.
A mask can't hide the truth, and the truth is in the map, messages, and motive. It was Friday, March 6th, 2020. Mackenzie Brackman, a local defense attorney, was alone in his home on South Flower Street when a masked intruder tried to enter his front door, but it was locked. The Ring doorbell security system was set off. The intruder went around to the back of the residence, and in a panic, the victim grabbed a kitchen knife to defend himself. When the intruder entered through the back door, a struggle quickly ensued over that knife. The defendant wrestled the knife away from the victim before stabbing him in the back. That is when the defendant ran. The victim tried to follow to the front door before pulling out the knife and rapidly bleeding to death. Mackenzie Brackman died in that home invasion. But that intruder's mask, Avery Becker's mask, can't hide the truth. And the truth is in the map, the messages, and the motive. After a thorough investigation, we charged Avery Becker with 2 counts: murder in the first degree and second-degree burglary of a dwelling. But to understand murder in the first degree, first we had to talk about second-degree burglary of a dwelling. It says that on or about March 6, 2020, Avery Becker broke an entrance into or unlawfully entered a dwelling with the intent to commit criminal mischief, which simply means to damage another person's property. Now, let's talk about first-degree murder. The judge will tell you that Avery Becker is guilty of first-degree murder if Mackenzie Brackman was killed by anyone, while Avery Becker was committing second-degree burglary or an immediate flight from the scene. We will meet our burden and prove the defendant guilty of both charges because a mask can't hide the truth. And the truth is in the map, messages, and motive. Let's break that down. A map. You will hear from Detective Jordan Markowitz, the lead investigator in today's case. She will tell you about call detail records that put the defendant's phone at the victim's house at the time of his murder. You will hear how the phone movements show the defendant staying there long enough to commit the crime. Speaking of phones, pay close attention to the messages Avery Becker sent to Alex Cifuentes, a teammate of Miss Becker. She will tell you how this kind of mischief wasn't out of the ordinary for the defendant. After all, Miss Becker had vandalized the victim's car only days before. You will hear how in these text messages, the defendant confessed to planning to commit this crime just before Mr. Brackman's home was broken into and he was murdered. Now, we've talked about map, we've talked about messages. Let's talk about the motive. You might be asking yourself, why would a high school student commit such a crime? You will hear how the victim was the defendant's mock trial coach. You will hear all about the bad blood between them and how upset the defendant got when she was kicked off the mock trial team. You will hear from Kyle Kuzak, a crime scene reconstructionist who worked with Detective Markowitz on this case, and she will tell you how the crime scene is consistent with the defendant's motive and how this was a burglary gone wrong, just like what Ms. Becker threatened to do in her text to Ms. Cifuentes. But for everything you'll hear today, you won't hear that the defendant intentionally killed the victim, because that's not what happened, and it's not what we charged the defendant with committing. Instead, this was a burglary gone wrong, and Mackenzie Brackman died as a result. That is first-degree murder. A mask can't hide the truth, and the truth is in the map, messages, and motive. At the end of today's trial, it will be clear Avery Becker committed this crime, and that is when my co-counsel, Ms. Buchin, will ask you to deliver justice for the victim and find Avery Becker guilty of both charges. Thank you.
Thank you, Ms. Feeney. And then Ms. Braun, does the defense wish to give an opening at this time?
Yes, Your Honor.
All right, you may do so. Thank you.
May it please the court?
It may. Thank you.
Your Honor, opposing counsel, ladies and gentlemen of the jury, we are here in today's case because my client, Avery Becker, is being falsely and wrongly accused of murdering her mock trial coach, Mackenzie Brackman, who was found dead in the doorway of his home. Mr. Brackman and Avery Becker had hit rough spots in the past, and opposing counsel will try to use their rocky relationship as a motive to kill. They will try to attack an innocent child for her adolescent mistakes, such as writing Worst Attorney Award with what she had believed to be a dry erase marker on the hood of Mr. Brackman's car. Avery was then kicked off the team after the dry erase marker proved to be permanent. Mistakes are made to be learned from, and Avery understands the guilt of her actions. But what her actions did not consist of was murder in the first degree, nor did it consist of burglary in the second degree of a dwelling. Opposing counsel's arguments will prove to be more prejudicial than probative, which in the court of law prohibits such evidence or statements from being admitted. In today's case, the prosecution has the burden of proving beyond a reasonable doubt that my client, Avery Becker, was guilty of the crimes charged. But Avery Becker is innocent until being proved guilty. My co-counsel and I will continue to support and exemplify Avery's innocence through the testimony of the defendant herself, Avery Becker, Avery's friend and fellow mock trial student, Taylor Perkins, and lastly, Detective Blake Van Owen. Avery Becker will testify her whereabouts on the day of Mr. Brackman's death, as well as explain how her past mistakes and rocky relationship with Mr. Brackman would never cause her to kill. She will also prove that not only had she never been to Mr. Brackman's house, but she had no idea where he lived. Taylor Perkins will testify to Avery Becker's alibi at the time of Mr. Brackman's murder. She will also explain that Avery Becker tried to make amends with Mr. Brackman after the series of incidences and arguments. Perkins will furthermore testify that Avery was passionate for mock trial and cared for every person in her team, including the coach of whom she struggled to form a bond. The defense's last witness is Blake Van Owen, who will show you hard proof that Detective Markowitz had taken the easy route with her investigation, leaving us with a report that just does not add up. On the prosecution side, you will hear from Kyle Cusack, crime scene reconstruction investigator. With a fancy title such as this, there's high expectations for this witness, but pay close attention to her testimony. She will testify on evidence there is no proof of. Kyle Cusack testifies against Avery Becker, yet and never even says the name Avery Becker in her affidavit. Cusack even states, "The physical evidence in this case leads me to one conclusion, but no physical evidence can prove her testimony beyond a reasonable doubt." Pay close attention to Detective Markowitz's testimony. She will choose one suspect based on 2 screenshots of text messages that they never even saw alone, and went with the easiest answer, which, as we will show you, is not the right answer. Detective Markowitz rushed her investigation. Markowitz will show no credibility and leave us to trust her word in a case that balances on the future of a child. The prosecution will prove time and time again through their witnesses that they were rushed, and when you're rushed, you miss things. Lastly, you will hear from Alex Cifuentes, a friend of Avery's who competed for significant roles in mock trial. She will testify to showing real accounts of text messages between herself and the defendant, but has no physical evidence to show these texts. Alex will use her own personal grudges against Avery to distract from her lack of evident proof. You will hear the name Blair Rowlands. Blair Rowlands is the insignificant third party, but in reality, Blair Rowlands is responsible for the text messages between Alex Cifuentes submitted to the police. Blair Rowlands is the one responsible for Mr. Brackman's death. As Winston Churchill once said, the truth is incontrovertible. Malice may attack it, ignorance may deride it, but in the end, there it is. The truth in today's case is that the malice attacked and accused an innocent child of a heinous crime, and that child is completely and utterly innocent. At the conclusion of this case, my co-counsel, Layla Moore, will give the closing argument. The judge will then give you the jury instructions and send you to deliberate. When you examine the facts and compare it to the law, you will see that prosecution has failed to meet their burden, leaving you with the only plausible verdict of not guilty. Thank you.
Thank you, Ms. Braun. And then Ms. Feeney, would the prosecution like to call their first witness?
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Ms. Cifuentes, I will just remind you that you're under oath, all right?
Yes, Your Honor.
Great. All right. Thank you.
Before I begin, can Your Honor see and hear me all right?
I can. Thank you very much.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Alex Cifuentes, and I'm a senior this year at Colorado High School.
How are you feeling about testifying here today, Ms. Cifuentes?
Well, nervous. I just want justice for my mock trial coach, Mr. Brackman. It's been really hard knowing that he's gone and that I'd have to tell a jury about what Avery did.
Now, before we get to that, could you tell us a little bit about Mr. Brackman?
Well, Mr. Brackman was an incredible attorney and an even better mock trial coach. I mean, he seemed to really care about everyone on the team doing their best.
And based on your observations and perceptions, did everyone else on the team have a good relationship with Mr. Brackman?
No, most people liked him, but his relationship with my teammate, Avery Becker, wasn't as great.
How so?
Well, they would argue at almost every single practice. Avery didn't do things the way Coach wanted her to, and Coach would call Avery out on it. It got so bad that Avery was kicked off the team 2 different times.
Your Honor, at this time, I ask the court to order the defendant to turn on their camera for purposes of identification.
Thank you. If the defendant would turn on the camera.
Ms. Cifuentes, do you see the defendant here in court today?
Yes, I do.
Could you identify her by an article of clothing and the title of her video?
She's wearing a black jacket and a white shirt, and the title of her video is Avery Becker in parentheses.
Let the record reflect that the witness has identified the defendant subject to cross-examination.
The record will so reflect.
And at this time, the defendant may turn their camera off. Ms. Cifuentes, you mentioned arguments between Ms. Becker and Mr. Brackman. Were there any such arguments in the days leading up to Mr. Brackman's murder?
Yes, there was one 3 days before Mr. Brackman was killed. It was that Tuesday, and they were arguing about the competition that happened that weekend.
Tell us about that.
Well, Coach was telling Avery that she needed to put in more work before the state tournament. Avery got really upset about this. She grabbed one of the Sharpies that we were using to write down notes with and stormed outside. Later, I found out she rode on Mr. Brackman's car.
How did Mr. Brackman respond to this?
Well, he immediately kicked Avery off the team.
To the best of your knowledge, did Ms. Becker ever attempt to get back on the mock trial team?
Yes, she actually texted me asking if I'd be willing to talk to Brackman.
Now, I'd like to shift the focus to what happened after Mr. Brackman was murdered. Were you ever asked to come in for an interview by Detective Markowitz?
Yes, I was.
About what specifically?
Well, when Detective Markowitz first reached out to me, I told her about these texts that I had from Avery, and she asked if I'd be willing to come in for an interview.
Did you preserve these texts for Detective Markowitz?
I did. I unfortunately forgot my phone at home when I went to the interview, but she said I could send her some screenshots of the text.
Let the record reflect that my trial technician is displaying Exhibit 14.
Thank you, Ms. Feeney.
What is this exhibit?
Well, these are the texts from Avery that I was just telling you about.
Just to clarify for the jury, whose texts are in green and whose are in gray?
The ones in green are the ones that I was sending to Avery, and the ones in gray are the ones that she was sending back to me.
And is this a fair and accurate depiction of your conversation with the defendant?
Yes, it is.
Your Honor, at this time, I move to admit Exhibit 14 into evidence.
Thank you, Mr. Loy. Is there any objection?
Yes, Your Honor. Objection to authentication lacking pursuant to Rule 901, and also hearsay to both contact name of the text messages as well as the body of the text messages.
Thank you, Ms. Feeney.
Yes, Your Honor. These texts can be proved to be authentic pursuant to Rule 901B1 through testimony of a witness with knowledge. As Ms. Cifuentes was the one to receive these texts, and she has testified that they did come from Avery Becker, they have been authenticated pursuant to Rule 901. As it relates to hearsay, this is not hearsay pursuant to Rule 801, as the statements in gray made by Ms. Becker are a statement of a party opponent pursuant to Rule 801D2, and the contact information at the top, as well as the statements in green made by Ms. Cifuentes, are not being offered for the truth of the matter asserted, but rather to provide context for Ms. Becker's statements.
Thank you, Ms. Feeney. Anything further, Mr. Loya?
Objection stands.
Thank you. So the court will overrule the objection with respect to 901, find that there's been sufficient authentication, at least testimony from this witness that these text messages were allegedly received from the defendant, and find that goes to weight and not admissibility. And then with respect to the hearsay, I'll overrule the objection as to the portions which are purported to have come from the defendant, which would make them admissions of a party opponent, and find that the other messages, those from the witness, are being used to give context for those statements and not for the truth of the matter. And so the objections are overruled, and for that reason, Exhibit 14 is admitted. Thank you, Mr. Loya and Ms. Feeney.
May I publish to the jury?
You may, thank you.
Now, Ms. Cifuentes, I'd like to draw your attention to the second text from Ms. Becker. What is this text referencing?
Well, this is Avery telling me that she got kicked off the team and asking if I'd be willing to talk to Brackman to help her get back on.
How did the conversation proceed from there?
Well, I told her that I wasn't sure anyone could change Brackman's mind, especially after what Avery did to his car. And that's when she showed her true colors.
What do you mean?
Well, she went crazy. I mean, you can see she threatens that if Coach is still mad about what Avery did to his car, then he's going to be really upset when he sees what Avery does to his house.
And did Miss Becker ever explain what she meant by this text?
Yeah, I mean, obviously I asked her, and she told me that she was going to wait until Coach was at work and then break in and trash his house.
Thank you, Your Honor. I have no further questions at this time.
Thank you, Ms. Feeney. And then Mr. Loya, any cross-examination?
Yes, Your Honor. Good afternoon, Ms. Fuentes.
Good afternoon.
Ms. Fuentes, you took mock trial pretty seriously, correct?
I mean, as seriously as you can. I worked really hard for it.
So you spent a lot of time on the mock trial team.
Well, yeah, I mean, it takes a lot of effort.
You practiced your closings,
Yeah, and a mirror helped me.
even practiced your openings.
Well, obviously, I mean, how else do you memorize it?
And you spent a lot of time revising, editing those openings and closings, correct?
As anyone good in mock trial does, yes.
Sorry. And you also took the time to rewrite a lot of these closings and openings until perfection, correct?
Yes, because I really cared about mock trial. I still do care.
Good. And you also spent countless hours of the law, correct?
I'm sorry, you cut out for a bit of that. Can you re-ask the question?
Of course. You also spent countless hours memorizing the rules of the law, correct?
Well, the rules for mock trial, not the actual rules of law.
Of course. However, you testified that Avery Becker did not spend the time to do so.
No, she didn't put in that much effort to mock trial. She was just kind of naturally charismatic, and it worked.
But she never came prepared to practice.
No, that's a lot of what her and Brackman argued about.
You also never came to practice. I never came prepared for regional tournaments.
No, she didn't.
And it's your testimony that you stated that Miss Becker won Best Attorney Award and Best Closing Argument, correct?
At last year's regionals, yes.
And you stated in your affidavit that you were frustrated by this.
Well, yeah, I think usually awards should go to people who work hard, not just those who are charismatic.
Of course. And this kind of created a little bit of jealousy for you, correct?
I mean, not really. She was on my team, so if she succeeded, we succeeded.
But it still kind of frustrated you how she won all these awards instead of you.
Like I said, it was just frustrating that I put in so much effort and she didn't.
And so you decided to get Avery back.
No.
And the night at the Fry Shack, you had the opportunity to do so.
No. And I don't know what night you're talking about. We went to the Fry Shack a lot.
Let me clarify. March 5th, 2020, the night before the murder.
Yeah, I was at the Fry Shack with the mock kids.
Okay. And at that night, you had access to Avery's phone, correct?
For a little bit, yeah.
And nobody was watching you while you had the phone.
I don't know if anyone was staring at me, but I was with the entire mock team.
Okay. And to clarify, you had complete control of Avery's phone. Is that correct?
No, I mean, I don't know her password or anything.
But you were in the phone, giving you accessibility to the phone.
For the couple minutes that she let me borrow it, yes.
Okay. And that would also give you the opportunity to open her text messages. Yes or no?
I suppose so.
And that would also give you the opportunity to send text messages to yourself, correct?
Yes, but I mean, it doesn't really make sense for me to do that. Why would I need to text myself from Avery's phone?
Yes or no?
Like I just said.
Yes. Okay. Moving on, it's also your testimony that Avery Becker texted you that night, correct?
No, she texted me shortly after the car incident.
Excuse me, my bad. And on direct examination, you testified about Exhibit 14, which are the text messages that you say that she sent, correct?
Yes, shortly after the car incident, which was on Tuesday.
And you agreed that these text messages were pretty important.
Now, yes, but then not really.
Would you agree that that these text messages show intent for a crime?
I mean, now looking back at it, definitely. At the time, I thought she was just frustrated. Thought she would sleep on it and decide against it.
And this would also show motive for Avery's intentions, correct?
I suppose so.
Matter of fact, these exact messages led Detective Markowitz to his only suspect, Avery, correct?
Objection, Your Honor. May I be heard?
You may, thank you.
This calls for speculation pursuant to Rule 701. As Ms. Cifuentes was not involved in the investigation conducted by Detective Markowitz outside of her interview, she cannot testify as to what Detective Markowitz thought regarding her investigation in today's case.
Thank you, Ms. Feeney. Mr. Loya?
Pursuant to Rule 701, this witness is totally in the scope of her knowledge due to a rational based perception. And as she was included in the investigation that Detective Markowitz gave to her, that would also give, I guess, what is it called? The conclusion that Avery Becker was part of a suspect list due to the fact that Ms. Cifuentes gave text messages showing Avery's intentions.
Thank you, Mr. Loya. Anything further, Ms. Feeney?
Yes, Your Honor. While Ms. Cifuentes was briefly involved in the investigation, as she had an interview with Detective Markowitz, she cannot testify as to what that interview caused Detective Markowitz to do, and it cannot be rationally based upon her perceptions and observations, making it speculation pursuant to Rule 701.
Thank you, Ms. Feeney. So I will overrule the objection at this point, Ms. Feeney. And so, Ms. Cifuentes, you can go ahead and answer the question, but I only want you to answer the question based upon your personal knowledge, not what somebody else told you, not what you speculate or think the answer might be, only if you know the answer.
Yes, Your Honor. I don't know what Detective Markowitz did or drew from text I provided.
Moving on, did you ever warn anyone after these text messages?
No, like I said, I thought Avery would sleep on it and decide against it.
So you didn't even tell the police immediately after receiving the text messages?
No, like I just said.
Did you even warn Mr. Brackman of these text messages?
No, like I just said. I didn't want Avery to get in more trouble than she was already in.
Okay. And just to clarify, you did not tell anyone of these text messages until after the murder had happened?
In the 2 days after I'd gotten them, no.
Okay. Moving on, do you know Blair Rowlands?
I think we went to school together.
And were you pretty good friends with Blair Rowlands?
No.
And you knew that Blair Rowlands' dad was on trial, correct?
Yeah, it was kind of known around the school.
And you knew that Mr. Brackman was his attorney, correct?
Eventually, yeah. Not when it first came out, though.
And you also knew that Mr. Brackman did a poor job as his attorney.
I don't think he did a poor job. I think he was just convicted. Well, Mr. Rollins, not Mr. Brackman.
And so when he was convicted, you also know that Blair Rowlands' dad threatened Mr. Brackman?
No, I didn't know that.
Okay. No further questions, Your Honor.
Thank you, Mr. Loya. Any redirect, Ms. Feeney?
First, may I inquire as to how much time is remaining?
You may.
Prosecution has 19 minutes and 8 seconds remaining.
Yes, Your Honor.
Thank you.
Ms. Cifuentes, did you bear any resentment towards Ms. Becker for her performance in mock trial?
No, of course not. I mean, she was on my team. If she succeeded, we succeeded, like I said.
And would you ever want to get her in trouble for succeeding?
No, of course not.
When was the last time you saw Ms. Becker's phone?
I saw it when Avery was leaving the fry shack with it.
Did you fake the text messages shown in Exhibit 14?
No, I mean, I don't even know how to.
Thank you, Your Honor. I have no further questions.
Thank you, Ms. Feeney. And did you have any recross, Mr. Loya?
No, Your Honor.
Great. You may step down, Ms. Cifuentes. Thank you very much. With that, Ms. Carrington, does the prosecution have another witness they would like to call?
Yes, Your Honor, the prosecution calls Detective Jordan Markowitz to the stand.
Thank you. Detective, I'll just remind you that you remain under oath, okay?
Good
All right.
afternoon. Good afternoon. Would you please introduce yourself to the jury?
Good afternoon. My name is Detective Jordan Markowitz, and I'm a homicide detective with the DPD.
How long have you been involved in law enforcement?
I've been with the DPD for the past 13 years, 7 of which I've been a detective.
Do you have any unique knowledge or skills that you relied on in this investigation?
Yes, actually, I relied heavily on my knowledge in crime scene investigations, specifically regarding any cellular data.
Do you have any certifications in these fields?
I do. I have cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
Have you ever used this knowledge and skills in other cases you've investigated?
Absolutely, all the time, especially given how prevalent mobile devices and their data are in today's society.
Your Honor, at this time, I ask that the court recognizes Detective Jordan Markowitz as an expert in crime scene investigation with an emphasis in the forensic analysis of cell phones and call detail records.
Ms. Moore? Any objection?
Your Honor, I request to voir dire this witness, please.
You may, thank you.
Thank you. Good afternoon, Detective. You said you've been a part of the Denver Police Department for 13 years?
That's correct.
And you also said that you have a cell phone technology and forensic data recovery certification?
Oh, yes.
And you received this from just a 3-day course?
Well, yes, the 3-day course was actually the longest course I could take. They also had a 24-hour and 48-hour course.
Yes. And do you have this certificate or proof of certification here today?
Unfortunately, not with me. It's back at the station.
And you have no proof of your credentials at all?
If you actually need proof of my credentials, I suppose I could have brought the certificate, but no, I don't have it with me.
And you also haven't stated that you have any formal education?
I didn't state that in my affidavit, but I went to both high school and college.
Your Honor, I object to the admission of Detective Jordan Markowitz as an expert because I feel that they have not laid proper foundation, and the only way we have to admit this witness as an expert is based on testimony with no exhibits or proof of certification.
Thank you, Ms. Moore, and then Ms. Carrington.
Yes, Your Honor, pursuant to Rule 702, a witness may be recognized as an expert if they testify to knowledge, skill, training, education, or experience. Detective Markowitz has testified to her knowledge, skill, training, and experience in the field in the fields tendered, and therefore she is qualified to testify as an expert in these fields.
And then any further argument, Ms. Moore?
I stand by my objection, Your Honor.
Excellent, thank you. And so courts consider the testimony that's been offered with respect to Detective Markowitz's qualifications. I do find that there's been sufficient testimony regarding education, training, and experience to qualify the expert as such, and therefore will overrule the objection and recognize Detective Markowitz as an expert in the area of crime scene investigations with an emphasis in forensic analysis of cell phones and call detail records, and permit her to give opinion testimony as such. Thank you both, and you may go ahead, Ms. Carrington.
Yes, Your Honor. How did you become involved in this case, Detective?
Well, I initially responded to a request for a detective, and I arrived at the scene at approximately 2:20 p.m. And when I got to the scene, the first thing I noted was that the front door to the residence was open and the victim was lying face down just inside the doorway, surrounded by a pool of blood. I also took note of a large kitchen knife that was on the ground near the body.
So what did you do first?
The first thing I did was call in a couple of our investigative teams. The first person I called in was our forensics team, and then I called in Kyle Kuzak, our crime scene reconstructionist.
Since Ms. Kuzak was the one who reconstructed this crime scene, we'll talk to her more about the details of the scene. But what was the next step in your investigation?
The next step in my investigation was to obtain the victim's cell phone so that we could download all of the data to see if there might be anything of relevance to the case.
Did you find anything significant on Mr. Brackman's phone?
Yes, actually, we found 2 pieces of data that were significant.
Tell us about those 2 pieces of data.
Of course. The first thing that we found was that the victim had a Ring doorbell app on his phone. From that, we were able to gain access to several videos of the suspect entering and leaving the home. The second thing we found was that the victim had a lot of contact with a mock trial team, so that gave us a lead to follow up on.
Let's start with the Ring doorbell videos. Did you preserve each of those videos for trial?
Yes, I did.
Your Honor, at this time, let the record reflect that my trial technician is displaying exhibits 10 through 13 on the screen. Do you recognize these exhibits, Detective?
Sorry, Ms. Carrington. It displayed right when I was going to unmute, so the record will reflect. Thank you.
Yes, Your Honor. Do you recognize these exhibits, Detective?
I believe I do. However, I can't actually read the links.
Your Honor, may my trial technician have permission to zoom in on these links so that my witness may properly identify them?
Yeah, that would be helpful. Thank you.
So what are these exhibits, Detective?
These are the links to the Ring doorbell videos that I downloaded from the victim's cell phone.
Are these fair and accurate representations of the links to the videos?
Yes, they are.
Your Honor, at this time, I move for the admission of exhibits 10 through 13 into evidence.
Great. And so, Ms. Moore, any objections to either 10, 11, 12, or 13?
No objection, Your Honor.
Thank you. Exhibits 10, 11, 12, and 13 are all admitted.
Thank you, and we can take those down for now and we'll return to them during Ms. Kuzak's testimony. Now, Detective, you mentioned another lead you found on the victim's phone. Could you tell us more about that?
Of course. Like I was saying, the victim had a lot of recent contacts with a mock trial team. So we reached out to a couple of students that were on that team. First, we spoke to Miss Alex Cifuentes. It immediately became clear to me that she had some important information, so I asked her to come on down to the station for an interview.
Did you learn anything significant from that interview?
We did.
What did you learn?
We learned that Ms. Cifuentes had recently been in contact with the defendant in today's case, and that the defendant had sent her a lot of text messages claiming to want to break in, and trash the victim's home.
Let's bring exhibit 14 back up on the screen as it was previously admitted. Your Honor, permission to publish this exhibit to the jury?
You may. Thank you.
Now, Detective Markowitz, earlier we heard Alex Cifuentes talk about these text messages, but how did they impact your investigation?
I'm glad you asked. As you can see, these text messages provide a really important window into what Avery Becker was thinking regarding this crime. Furthermore, they're incredibly consistent with the evidence we gathered at the crime scene.
Thank you. Exhibit 14 is no longer needed. Based on the information in these text messages, what was the next step in your investigation?
The next logical step was to get Avery Becker's cell phone. This would be to corroborate the validity of those texts and also to confirm her whereabouts on March 6, 2020. However, unfortunately, we were unable to gain access to her cell phone as she claims to have lost it just days prior to the crime.
So what did you do instead?
We subpoenaed for Avery Becker's call detail records. We'll call them CDRs for short.
What is a call detail record?
CDR tells me the location of a cell tower that a phone is connected to at any given point when it receives a digital communication, such as a call or a text. And based on that information, I can actually visualize where a suspect might be at any given point.
Excuse me. Using these call detail records, were you able to figure out where the defendant was at the time of the homicide?
Yes, actually. And there were a couple of maps that were helpful in my investigation that I think would help the jury understand really what was going on.
Your Honor, let the record reflect that my trial technician is displaying exhibits 15 and 16 on the screen.
Thank you, Ms. Carrington.
Do you recognize these exhibits, Detective?
Yes, I do.
What are they?
Well, Exhibit 15 is a map that was prepared based on the CDR data that we collected from Avery Becker's cell phone. And Exhibit 16 is that same map, but it also has a potential route that the defendant could have taken to get to the victim's home.
Are these maps fair and accurate representations of the data you collected from Avery Becker's cell phone?
Yes, they are.
Your Honor, at this time, I move to admit exhibits 15 and 16 into evidence.
Thank you, Ms. Carrington. Any objection, Ms. Moore?
Yes, Your Honor. I would like to object to lack of foundation. Specifically in Exhibit 16, the dotted line, I feel as though we have laid absolutely no foundation onto how the detective could have known a specific route driven.
Ms. Carrington?
Yes, Your Honor. Detective Markowitz just testified that this was a potential route based on the times and location of the defendant's phone. Therefore, foundation has been laid as to how Detective Markowitz would know what this route is.
Thank you, Ms. Carrington. Anything further, Ms. Moore?
Your Honor, I stand by my objection to lack of foundation because although she can testify as to the cell records and to the cell records that she received, I don't believe that she can testify exactly where the defendant would have driven if she has not laid more foundation.
Thank you. So at this point, I'll go ahead and overrule the objection and find that there's been sufficient foundation. She is an expert and is permitted to give opinion testimony based upon her review of cell phone data, and you can certainly cross-examine her on how she reached those opinions on cross-examination. And so given that, exhibits 15 and 16 are also admitted.
Thank you, Your Honor.
Thank
Permission
you.
to publish to the jury, Your Honor.
You may, Ms. Carrington. Thank you.
Detective, using these exhibits, can you describe for the jury the route that matches both the time and location of the defendant's phone?
Yes. As you can see, the defendant's phone starts out by her house in the upper quadrant, and then her phone pings a cell tower between her home and the victim's home once, and then it begins pinging the quadrant that contains the victim's phone around the time that the crime took place.
So what does all this mean?
To a reasonable degree of scientific certainty, this means that the defendant's phone was at the victim's home for at least 12 minutes during the time that the crime took place.
Thank you. Exhibits 15 and 16 are no longer needed. Now, Detective Markowitz, in your expert opinion and based on your investigation, was Avery Becker involved in the break-in that led to the death of Mackenzie Brackman?
Yes. In my expert opinion, Avery Becker went to Mr. Brackman's home. During the course of that intrusion, Mr. Brackman was killed by Ms. Becker.
Thank you, Your Honor. I have no further questions at this time.
Thank you, Ms. Carrington. Cross-examination whenever you're ready, Ms. Moore. And actually, yeah, go ahead.
Yes, Your Honor. Detective, you just testified on direct examination that you wanted to receive Avery Becker's phone for purposes of corroborating the validity of the text messages.
That's correct.
But you were not able to receive this phone, so you were not able to corroborate the validity?
We were not able to prove that they were valid based on Avery's phone. However, we were able to prove that through Alex Cifuentes.
Yes, thank you. And you retrieved the videos from Mr. Brackman's Ring system on March 6th, correct?
Yes, we did.
And who is in these videos?
Avery Becker, evidently.
But you can't see Avery Becker's face in any way?
You can't see her face, no, but it is clearly her based on the height and build.
And there were no eyewitnesses at all?
No, there weren't.
And you also said that it is absolutely clear that this was meant as an attempted burglary?
It is clear that it is an attempted burglary.
But you also said that many expensive items were left undisturbed?
Yes, keyword attempted. Clearly it went awry as Brackman is dead.
And so there is no evidence of theft?
No, like I just said.
And there were no fingerprints at the crime scene?
There were not, which is consistent with the suspect wearing gloves, as we can see in the videos.
And you found no footprints at the crime scene?
That's correct.
So at the scene, there is no physical DNA evidence of who could have done this?
No, but again, that's consistent with what we know from the videos.
And you also said that it seemed highly unlikely that Brackman's mock trial activity had anything to do with his death?
Originally, it seemed unlikely, but the facts of the case did lead us to mock trial.
And you also said that the evidence and videos led you to believe that this was just a random burglary.
Originally, that is where the evidence led us. However, ultimately, that is not what happened.
Yes, because you considered Avery Becker a suspect after seeing some screenshots of some text messages, correct?
That was one piece that played into our investigation, yes.
And you considered these screenshots the biggest break in your case?
They were one break.
And you received these roughly 3 months after the murder?
I believe that is when we interviewed Ms. Fuentes, yes.
But you didn't even see these messages yourself, right?
I did. You've seen them in the case today as well.
Well, I know we have seen screenshots, but did you ever see these physically on Alex Fuentes or Avery Becker's phones?
We did not see them on the cell phone. However, the screenshots were sufficient in today's case.
And you said that this could have been a disgruntled ex-client of Attorney Brackman's?
Yes, that was one of our original theories. However, there was no proof of that in today's case.
But you did conclude that there was a struggle, correct?
There was, yes.
Detective, did you review the autopsy report in today's case?
Yes, I did.
Your Honor, let the record reflect that I am showing opposing counsel what has been previously marked as Exhibit 19.
Thank you, Ms. Moore.
I'll scroll through this so you can look at it. Detective Markowitz, can you tell me what Exhibit 19 is?
Yes, this is the autopsy report.
And is this report accurate to the best of your knowledge?
To the best of my knowledge, it is, yes.
And you have, in fact, reviewed this report?
Yes.
And did you use this report to reach your conclusions in today's investigation?
It was a factor, yes.
Your Honor, I now move to admit Exhibit 19 into evidence.
Any objection, Ms. Carrington?
I have no objection to this, Your Honor.
Thank you. And so I believe that was Exhibit 19. Exhibit 19 is admitted.
Thank you. And in this report, it does not mention any bruising other than around the stab wound, correct?
No, but that, to my understanding, is consistent with the fact that Mr. Brackman died shortly after being stabbed.
And in this autopsy report, it shows no evidence of a struggle at all.
Well, again, it is my understanding that that is consistent with his untimely death.
And at the crime scene, you found blood spatter, correct?
Yes, we did.
And a broken plate?
That's correct.
And ring videos of an intruder?
Yes, again, all signs of a struggle.
And of course, this evidence is obviously proof that, in fact, a murder did occur.
Yes, I'm pretty sure we all agree that a murder occurred in today's case.
Yeah, of course. But this evidence does not prove that Avery Becker specifically committed this crime.
This evidence alone does not. However, the entirety of the evidence that we collected does.
And you also concluded that Avery Becker's phone connected to a cell tower near Mr. Brackman's home, correct?
That's correct.
But a phone doesn't always connect to the closest cell tower, right?
No, it does not. But since it pinged the cell tower multiple times, we can be reasonably certain that it was in fact within that area.
And are you aware that Avery Becker did not have her phone on the day of the murder?
I'm aware that that is what Avery Becker claims in today's case.
But a big part of your investigation was based on the location of her phone?
That was not a big part of our investigation. It was a portion, yes.
The phone that she did not have?
Again, I'm aware that is what Avery claims, but the facts do not support that.
And the intruder in the videos that we saw earlier is wearing a mask, correct?
That's correct.
And they're also wearing gloves
Yes.
and a black hoodie.
Yes, that is correct.
But you never searched Miss Becker's home, correct?
We did not, no.
And you didn't collect a hoodie from Avery Becker, correct?
No, we did not collect a hoodie, no.
And you didn't collect a mask from Avery Becker, correct?
No, we did not.
And you didn't collect gloves?
No, we did not. I assume she disposed of the disguise.
Yes, you assume so. Thank you, Your Honor. No further questions.
Thank you, Ms. Moore. Any redirect, Ms. Carrington?
May I inquire as to how much time I have remaining?
You may, thank you.
Prosecution has 9 minutes and 18 seconds remaining.
Based on that, no redirect, Your Honor.
Great. Detective, you may step down. Thank you. And then Ms. Buchan, does the prosecution wish to call an additional witness?
Yes, Your Honor. The prosecution calls Kyle Kuzak to the stand. May I have a moment to rearrange my virtual courtroom?
You may, thank you. And then, while Ms. Buchan's doing that, Ms. Kuzak, I'll just remind you that you remain under oath, okay?
Yes,
Great,
Your Honor.
whenever you're ready, Ms. Buchan, thank you.
And before I begin, can you hear and see me all right, Your Honor?
I can, it cut out just ever so slightly, but it's not been a problem.
Okay. Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Kyle Kuzak. I am a crime scene reconstructionist for the Denver Police Department. I'm commonly referred to as a CSR for short.
Now, a few minutes ago, Detective Markowitz established the different roles law enforcement had in this investigation. What was your role as the crime scene reconstructionist?
As a CSR, my job is to put together all of the forensic evidence in order to determine how a crime occurred. Therefore, in this case, I worked with the forensic team to determine the circumstances of Mackenzie Brackman's death.
And how long have you been involved in this field of work?
For about 19 years now, I've been reconstructing complex crime scenes for the duration of my career. And often these complex crime scenes involve home invasions, burglaries, property crimes, even homicides.
Are you certified to do what you do?
I am. I'm certified under the Colorado Bureau of Investigation.
And without telling us what that opinion is, have you reached an expert conclusion in today's case that would be helpful for the jury?
I have, yes.
Your Honor, at this time, I ask that the court recognizes Ms. Kyle Kuzak as an expert in crime scene reconstruction and investigation.
Thank you. Ms. Braun, any objection?
No objection, Your Honor.
All right, and so ladies and gentlemen of the jury, the court will recognize this witness as an expert in the area of crime scene reconstruction and investigation and permit her to give opinion testimony as such. Go ahead, Ms. Buchan, thank you.
Now, Ms. Kuzak, how did you first approach your crime scene reconstruction of this case?
Every crime scene is different, but part of my job is to standardize a process to come to the most scientifically sound conclusions when conducting reconstructions. So to that end, I always follow a 5-step analysis process and document as much information as possible throughout my 5-step analysis.
What evidence did you rely on to formulate your conclusions?
I reviewed all of the photographs that are included in the case file, all of the Ring doorbell security system videos, police reports, the autopsy report, and I also visited the scene of the homicide.
Let the record reflect my trial technician is displaying what has been previously marked as exhibits 1 through 9, as well as exhibit 18 for the jury. Ms. Kuzak, do you recognize these exhibits?
I do.
And what are they?
From top left to right, exhibits 1 through 4 are all photographs of the victim. Exhibit 5 is a photograph of the identified weapon, the knife, next to the victim. Exhibit 5 is a photograph I took of the weapon in a lab setting. And exhibits 7 through 9 are all photographs taken in the victim's residence, specifically the kitchen. And exhibit 18 are all photographs of the scuff marks found at the rear door.
And are these photographs accurate depictions of the crime scene that you personally saw?
Yes, they are.
Your Honor, I move to admit exhibits 1 through 9 as well as exhibit 18 into evidence.
Ms. Braun, any objection?
Yes, Your Honor, I object to cumulative and relevance.
And then your response, Ms. Buchan?
Of course, Your Honor. Pursuant to Rule 403, this is not cumulative, as each one of these images is unique in its own way. One image is taken from outside of the building looking in, one is taken from the inside looking out, one is zoomed in on the victim, and one is a victim of the wound itself. Each one of these photos is critical for the jury to see, as they show different perspectives of the crime scene, and they show different ways in which this crime scene unfolded. It's crucial for the jury to see these exhibits so that they can evaluate the evidence of Ms. Cusack as they hear her testimony today. Furthermore, Your Honor, pursuant to Rule 401, this is extremely relevant. Not only that, but relevance is a low bar in today's case. But today, the manner in which this crime occurred is at question in today's case, as Ms. Cusack and Professor Van Owen have differing opinions as to how the crime occurred. So it's very relevant for the jury to see these exhibits so that Ms. Cusack can testify to the way that the manner in which the crime unfolded in today's case.
And then any further response, Ms. Braun?
Yes, Your Honor, I do not see how Exhibit 2 through 4 should all three be admitted. I ask that if opposing counsel wishes to admit these exhibits, that she do one of these. I believe that each of them are practically identical to one another. Two and three, I apologize. 2 and 3 are essentially the same photo. One is just slightly zoomed in. And as for Exhibit 18, there are scuff marks that cannot be dated, so I do not see the relevance in Exhibit 18 as well.
Your Honor, may I respond?
Yeah, and I was going to ask you to I don't know what you're planning to respond to, but if you want to specifically address what you want to respond to, but then the scuff mark relevance as to Exhibit 18.
Yes, Your Honor. As opposing counsel said in her response, each one of these photos are different. As she stated, each one, Exhibits 2 and 3, are different representations of the body, and therefore are not cumulative because they are different representations and different perspectives of the victim, which are helpful for the jury to aid in their understanding of events. In pursuant to Rule 401, Exhibit 18 is also relevant, as Ms. Cusack has been tendered as an expert in crime scene reconstruction, and the scuff marks were found at the crime scene. It's relevant for Ms. Cusack to testify to these exhibits, especially to Exhibit 18, because it helps her describe how the crime was occurred, and it helps the jury understand another step in this crime in today's case.
Anything further, Ms. Braun?
Yes, Your Honor. The argument in today's case is not that there was any struggle or whether Mr. Backman was killed. That is just the fact of the case. What we are debating in today's case is that Avery Becker did or did not commit this crime. I do not see how Exhibit 18 proves or disproves Avery Becker's innocence. And as far as 2 through 4, I believe they're all essentially the same photo.
Great. Okay, thank you all. So Rule 401 defines what relevant evidence is. 402 says it should be admitted, and 403 says otherwise relevant information, if it meets one of 6 dangers, should be kept out. I agree that the rules as to relevance favor admission. With respect to Rule 403 and the cumulative objection, the rule specifically talks about evidence that is needlessly cumulative. There are variations within the 4 photographs. I have some level of concern given the nature of the photographs. However, given that, I will find that they are not needlessly cumulative and are relevant. I make the same finding with respect to the remaining photographs, including Exhibit 18, as it pertains to the testimony of this witness. And so I'll overrule the objections, find that any objection went to weight and not admissibility, and Exhibits 1 through 9 and 18 are admitted. Thank you both.
Thank you.
Yes, Your Honor. And with that, may we have permission to publish Exhibits 1 through 9, as well as Exhibit 18 and Exhibits 10 through 13, which were admitted on the direct examination of Detective Markowitz.
You may, Ms. Buchan. Thank you.
Now, let's start off by talking about Exhibits 10 through 12. Let's play Exhibit 10 for the jury. let's play Exhibit 11. And finally, Exhibit 12, please. Now, Ms. Kuzak, based on those 3 exhibits, can you explain what we just saw?
Of course. We just saw a perpetrator matching the general height and build of the defendant approach the victim's front door, which was locked. That is why we see the perpetrator proceed to the south side of the residence, open the back fence gate, and proceed into the backyard. And in that last video, we see that the perpetrator was opening the sliding glass door to the residence and proceeding into the home.
Now, let's display exhibits 8, 9, and 18 for the jury. Ms. Kuzak, based on these exhibits, what happened once the intruder entered the residence?
The perpetrator entered through the rear door of the residence. Therefore, Mr. Brackman was notified of this activity through the Ring doorbell security system. And at the side of this, he armed himself with a knife, which came from the kitchen knife block, as pictured in Exhibit 8 on the left of your screen. So when the perpetrator entered through the back door, a struggle ensued between the two, and the scuff marks were left behind as a sign of this. They were also up on your screen. Now, at some point, Mr. Brackman at one point, Mr. Brackman was alerted that the perpetrator took the knife from him, and actually he came at the perpetrator in a bear hug. Therefore, the perpetrator reacted by stabbing downward into Mr. Brackman's scapula.
Now let's display Exhibit 13, and at the end of that video, let's display Exhibits 1, 2, and 5. So go ahead and play Exhibit 13. And now let's show Exhibits 1, 2, and 5. Ms. Kuzak, based on these exhibits and Exhibit 13, what happened to Mackenzie Brackman?
As you see in that last Ring doorbell video, the victim fled the scene moments after the homicide, and Mr. Brackman's body was found just inside the opening of the front door, as seen in Exhibit 1 and 2. Now, based on those 2 photographs and the rest of the evidence all found at the scene, I came to a reasonable degree of scientific certainty that Mr. Brackman, after being stabbed in the scapula, followed the perpetrator to the front door. But Mr. Brackman actually forcefully pulled out the knife from his own scapula, which resulted in the nicking of his aorta. Therefore, it culminated in heavy, rapid bleeding that essentially terminated his life.
Thank you. You can take down those exhibits. And Ms. Kuzak, finally, based on your expert opinion and all of the evidence you've analyzed, is the evidence you've analyzed consistent with Avery Becker committing this crime?
Absolutely. In fact, all of the evidence on the scene describes a lot of what Detective Markowitz had previously described about Avery Becker's motives. And in fact, all of the evidence has strong correlation that Avery Becker was at the scene of the crime.
Thank you, Your Honor. Thank you, Ms. Kuzak. I have no further questions at this time.
Thank you, Ms. Buchan. And then, are you ready for cross, Ms. Braun?
Yes, Your Honor.
Great, you may proceed.
Ms. Cusack, you state that Ms. Becker is the murderer in today's case, correct?
Yes, that is correct.
Yet in your affidavit, you do not state the name Avery Becker.
That is correct.
And so your evidence that leads you to believe that Ms. Becker killed Mr. Brackman are the Ring videos. Is that correct?
Yes, actually, I mentioned in my affidavit that Avery Becker matches the height and build of the perpetrator. I don't state Avery Becker, however, I state the defendant, which is Avery Becker in today's case.
Right. And yet, Ms. Becker does not have a distinctive build. Is that correct?
I would say that the build seen in the Ring doorbell videos is distinctive. That's why we can match Ms. Becker to the perpetrator in the videos.
Right, but her build does not stand out of the ordinary in the human population, correct?
I would disagree, counsel.
Interesting. And her height does not also stand out of the ordinary, does it?
Once again, I disagree. Her general height and build is the reason why we distinctively correlated Miss Becker to this case. Well, one of the reasons.
I'll move on. Your Honor, let the record reflect I am presenting what's been admitted as Exhibit 5.
Thank you, Ms. Braun.
I will get that up once I can.
Yep.
I apologize for the, hold up.
No worries, take your time.
Ms. Cusack, would you agree that there's a significant amount of blood on the blade of this knife?
Yes, I agree.
And would you agree that there is also a significant amount of blood on the handle of this knife?
Yes, I agree.
And there is also a large pool of blood surrounding the knife.
Yes.
So if someone were to grab this knife, they would get a significant amount of blood on their hand. Is that correct?
That is correct.
Thank you. And now, Your Honor, I now move to present what's been admitted as Exhibit 4.
Thank you.
And Ms. Cusack, would you direct your attention to the hands of the defendant, or not the defendant, I apologize, the victim? And would you say that these hands are clean?
Well, from what we can see from the top of the hand, they look clean. However, within any of the photographs, really, we can't really see the palms of the victim.
Right. And so if we zoom in on the image, we can see that there is no blood on the hardwood flooring. Is that correct?
Not in this specific area. However, if you zoom down where the wound would be, there is a lot of blood on the floor. Yes.
Right. There is a lot of, whoa, I don't know what happened. Okay. I apologize. Do not know what happened.
Your Honor, I have an objection. May I be heard?
You may.
Your Honor, I simply ask that opposing counsel turn off their presenting while going through the exhibits, as some of these exhibits have not been entered into evidence.
And so I would sustain that objection if we were in a real trial. I'll acknowledge, Ms. Braun, I think you're having some technical difficulties, and so just instruct the jury to disregard anything that they're seeing except for Exhibit 5, which is what I would think you want to have displayed.
Yes, Your Honor. I apologize. I do not understand how this got so chaotic. Okay, so back to Exhibit 4.
Your Honor, I apologize for the interruption, but the defense has used all of their time for cross-examination.
So I think she was about a minute when we had that objection and technical issue. So go ahead and give her that minute back, since we were dealing with the technical issue.
Yes, Your Honor. I am very sorry for the difficulties. Miss Cusack, in the photos that we saw of Mr. Brackman, there was no blood on his hands that we could see, correct?
That is correct. That we could see.
Correct. Okay, thank you. No further questions, Your Honor.
Thank you, Ms. Braun. And then did you have any redirects, Ms. Buchan?
May I inquire as to how much time I have remaining?
You may, thank you.
The prosecution has 1 minute and 45 seconds remaining.
I'll present a redirect, Your Honor. Can I have a moment to rearrange my virtual courtroom?
You may, thank you.
Ms. Cusack, how do you know it was Avery Becker who was at the scene of the crime on the day in question?
There are some very specific signifiers. One of them would be the height and build of the perpetrator seen in the Ring doorbell videos. And of course, there's all of the evidence that Detective Markowitz talked about earlier. There are also the broken plate and the evidence of the struggle, like the scuff marks.
Thank you, Your Honor. I have no further questions. And at this time, the prosecution rests.
Great, thank you. Let me just make sure Ms. Braun doesn't have any recross.
No, Your Honor.
Okay, so given that the prosecution has rested, you may step down, Ms. Cusack. Thank you very much. And what I'm going to do now is go ahead and just pause for a minute to give the scoring judges a chance to catch up. If you would all mind, the three of you, just pop your video on and give me a thumbs up when you're ready to move on to the defensive side. Thank you, Mr. Wilmore. Thank you, Ms. Tate. Thank you, Ms. Starrett. Okay, so I believe everybody is ready to go. With that, I have entertained any halftime motions and denied them. I've also advised the defendant with respect to the defendant's right to testify or not testify. And so with that, yeah, I guess I'll turn to Ms. Braun, I believe, and is the defense calling any witnesses?
Yes, Your Honor, we call Taylor Perkins to the stand.
Great, thank you. And then your preferred pronouns, she, her?
Yes.
Okay, and I'll just remind you, Ms. Perkins, that you're under oath, okay?
Yes, Your Honor.
Great, whenever you're ready, Ms. Braun, thank you.
Thank you. Ms. Perkins, can you please state your name and spell your last name for the record?
My name is Taylor Perkins, Perkins.
Did you attend school last year?
Yes, I did. I was a senior.
And where did you attend school?
Colorado High School.
Did you participate in any extracurricular activities?
Yes, I was in an after-school club called Mock Trial.
And what is your connection to today's case?
I know the exact whereabouts of Avery Becker on the day of the murder.
So you know Avery Becker?
Yes, Avery Becker is my best friend.
Are you close with Avery Becker?
I would say very.
And do you know the victim, Mr. Mackenzie Brackman?
Yes, I do.
And how do you know Mr. Brackman?
He was the mock trial coach for the team I was on.
What can you tell us about Avery Becker and Mr. Brackman's relationship?
Well, from my personal perception, I'd have to say it wasn't always the best. There were always arguments and fights going on here and there.
Who were these arguments between?
It was mainly between Avery Becker and Mr. Brackman.
And did this cause any conflicts on the team?
I'd have to say sometimes it did and sometimes it didn't. It would just depend on the type of fight it was or argument.
Could you please give an example of a fight that happened?
Well, there was one time when Avery had come to practice the most unprepared I think I've ever seen. And this really got to Brackman. So Brackman unfairly demoted Avery Becker to the B team.
And what happened when Ms. Becker was demoted?
She acted out of emotion and grabbed a permanent marker and went out and wrote on Coach Brackman's car.
And what happened after this?
After this, Brackman was very upset with the situation and kicked Avery Becker off of the mock trial team.
What happened after Avery was kicked off the team?
Well, she came to me and we went to the Fry Shack at the mall and we just sat there and hung out for a little bit.
And what happened at the Fry Shack?
Well, the rest of the mock trial team showed up after we had already been there for a little while. And Avery and I were talking to the team and they were saying how unfair it was. And even Alex Cifuentes, who Avery really doesn't like that much, was even trying to confront her. And I mean, Alex said something that put Avery over the edge and she got really upset and she ran to the bathroom, leaving her phone at the table. Really took me by surprise.
And did anything happen after this?
Well, after this, she came back to the table, she didn't grab her phone, or at least I didn't see her grab her phone, and we left.
And what happened the next day?
Well, the next day is when we realized that she actually did not grab her phone, and we were supposed to go to school together, and that's when we realized. And so since we thought that we didn't really have anything important going on at school, we decided to ditch, and we went to the Fry Shack in the mall and retraced our steps to try to find her phone.
And where all did you go specifically?
Specifically, we went to the mall and the Fry Shack.
And did you go to Mr. Brackman's home?
I don't even know where he lives.
Did Miss Becker go to Mr. Brackman's home?
Well, she was with me the whole day, and now she doesn't even know where he lives, so no.
No further questions, Your Honor.
Thank you, Ms. Braun. Ms. Buchan, cross-examination.
Yes, may I have a moment to rearrange myself?
You may. Thank you.
Ms. Perkins, I'd like to start off by talking about the map. Let the record reflect that my trial technician is displaying what has been previously marked as Exhibit 16.
Thank you.
Ms. Perkins, you saw this exhibit earlier today?
Yes.
And if you look at this exhibit, you can see the defendant's home in the top shaded region, yes?
Objection relevance.
Ms. Buchan?
Yes, Your Honor. Pursuant to Rule 401, this is relevant. I'm simply asking Ms. Perkins if that is the location of Ms. Becker's home. I'll be questioning further about the location of her alibi, and that is why it's relevant in today's case.
Thank you. Anything further, Ms. Braun?
Your Honor, this was used as an expert's exhibit, and Ms. Perkins, this has no relation to Ms. Perkins, as this is beyond her scope as well.
May I respond, Your Honor?
Yeah, as to that.
Your Honor, I'm not asking Ms. Perkins to testify or opine on an expert level. I'm simply asking questions to the bias and credibility of the witness pertaining to her alibi, which is a proper cross-examination.
So the exhibit's been admitted, and to the extent that the witness is familiar enough with it to utilize it in her testimony, I'll overrule the objection if she knows she can answer. At this point, you're not asking her about any of the underlying expert data that generated the mapping. And so if it becomes an issue, Ms. Braun, you can re-raise your objection.
Thank you, Your Honor.
Now, once again, Ms. Perkins, that's the defendant's home in the top shaded region?
I'm sorry, I can't see that very well. Could you zoom in?
Yes. Permission for my trial technician to zoom in on the defendant's home for purposes of clarification?
That'd be fine.
Your Honor, my trial technician has just stated that she can't zoom in on that exhibit. Is it all right if I keep going?
You may, yeah. If you're just withdrawing the question at this point, then.
Sure. So, Ms. Perkins, you would agree that you heard the detective testify to cell towers tracking Avery Becker's route to the defendant's house, correct?
Yes, I did hear that from the detective.
And earlier you testified to going to the Fry Shack and to the mall?
Yes, I did.
But when looking at that exhibit, neither the Fry Shack nor the mall were in any of the red shaded regions, were they?
That's because Avery didn't have her phone and we went to the Fry Shack to look for her phone. So I couldn't tell you. I mean, maybe someone took her phone and that's why they're in those regions. But other than that, we were out looking for her phone. And so I can't tell you whether
I don't mean to interrupt you, but I'd like to bring you back to my question. Yes or no, the Fry Shack is not in the red shaded region?
That is correct. It's not.
Now, we've just talked about the map. I'd like to talk about the messages. Let the record reflect that my trial technician is displaying what has been previously marked as Exhibit 14.
Thank you.
You would agree that after the defendant was kicked off the team, the two of you thought of ways for her to get back on?
Yeah, that's true.
And when looking at this exhibit, that's Avery's name at the top, right?
Yes, it is.
And when you texted people to get back on the team, that included Alex Fuentes, yes?
Objection. This is beyond the witness's scope of knowledge.
Ms. Buchan?
Your Honor, it's not beyond the scope of the witness. As in her affidavit, it says that she thinks Alex Fuentes was even texted by Avery Becker. Therefore, it's not outside of the scope of the witness, and I'm simply asking her to testify to her own observations and perceptions.
So to the extent that the witness doesn't know, she can certainly testify that she doesn't know and so I'll overrule the objection.
So once again, Ms. Perkins, the defendant even texted Alex Fuentes.
From this exhibit, that appears to be true.
Have you ever said, I think even Alex Cifuentes?
I'm sorry, can you restate the question?
Have you ever said, I think she even texted Alex Cifuentes?
Yes, she did, because she thought that since her and Alex were at least teammates, that Alex would try to help her at least a little bit on trying to get back on the team.
That's right. So now in looking at this message chain, it has the defendant asking for help to get back on the mock trial team, yes or no?
From what it looks like, yeah.
But thank you. This exhibit is no longer needed. Now we've talked about the map. We've talked about the messages. Now I'd like to talk about the motive. Let's talk about the relationship between Avery Becker and the defendant to the best of your knowledge. The two of them had a feud, yes?
Yes, they did.
And the feud bothered the defendant, didn't it?
It made her upset every now and then, but I wouldn't really say that it bothered her all the time. And from the best of my knowledge, I can't really say for Avery whether or not that's true, because I'm not Avery.
I understand, Ms. Perkins, but have you ever said, I think it even bothered Avery?
Objection asked and answered.
May I respond, Your Honor?
May, thank you.
Your Honor, although I did ask this question a second time, it was for purposes of clarification. I was redirecting the witness back to my question so that the jury can get a clear answer about the question I was asking.
All right, I'll overrule it.
So that's a yes to my question, Ms. Perkins. You have said those words.
Yes.
And to be fair, the defendant or the victim was mean to the defendant.
From my perception, yes.
The victim was always on the defendant about something. Your words.
I suppose, yes.
But you would agree that the defendant could be rash and had an inflated ego?
At times, yes.
And a couple days before Mackenzie Brackman was murdered, the defendant vandalized his property, the Porsche. Am I correct?
Objection, assuming facts not in evidence.
Your Honor, during opposing counsel's direct examination of Taylor Perkins, opposing counsel asked questions regarding the vandalization of Mr. Mackenzie Brackman's car. So these facts have been put into evidence. This was also testified to on the direct examination of Ms. Cifuentes as well.
Thank you. Ms. Braun, anything further?
Yes, Your Honor. Opposing counsel is referring to the incident with the Porsche as a vandalism, which was never called vandalism, but only an incident.
Okay, I'll sustain the objection and just ask you to rephrase the question, but go ahead.
Thank you, Your Honor.
Now, Ms. Perkins, a few days before Mr. Brackman was killed, there was an incident regarding Mackenzie Brackman's car, and the defendant wrote on it, yes?
A harmless incident, yes.
And then after being kicked off the team, the defendant tried everything to get back on.
I mean, yeah, she loved mock trial. She hated being off the team, and she just really wanted to be back on the team.
And it's true that the victim even tried to do so the day before Mr. Brackman was murdered, yes?
I'm sorry, you cut out. Could you please repeat that?
The defendant tried to get back on the team the day before the victim was killed, yes or no?
Yes.
But the victim never changed his mind.
Objection.
No.
Sorry, so let's go ahead and have you make your objection, Ms. Braun. I think it was a speculation, but go ahead.
Yes, Your Honor. I objected to speculation because she asked regarding the victim's decisions and thoughts, and Ms. Perkins cannot testify to those.
Thank you, Ms. Fusion.
Yes, Your Honor. This is not speculation pursuant to Rule 701, as this is rationally based on the witness's observations and perceptions. It's very clear to everyone today that the defendant or that the victim never changed his mind regarding letting Avery Becker back on the team, as no one has testified today that Avery Becker was put back on the team after his death. Therefore, I'm not asking Ms. Perkins to testify about the mental state or to speculate about the victim, simply to testify to the truth that the defendant was never put back on the team.
All right. So to the extent that you have personal knowledge of that, you can testify you can answer the question. To the extent it requires you to speculate or you're just guessing, then the answer is I don't know. So I will overrule the objection and you can answer based on your personal knowledge.
So that's a yes to my question, Ms. Perkins.
I'm sorry, what was the question again?
The victim never changed his mind, yes or no?
No, I don't believe he did.
And the next day, he was found dead in his house.
Yep.
Thank you, Your Honor. I have no further questions.
Thank you, Ms. Buchin. And then any redirect, Ms. Braun?
No, Your Honor.
All right, you may step down, Ms. Perkins. Thank you. And then does the defense wish to call an additional witness?
Yes, Your Honor. The defense. Excuse me, sorry, we had a few
You're good, Ms. Moore. Thank you.
The defense calls Blake Van Owen to the stand.
Great. And then Blake, are you a Ms. Blake?
Yes.
All right. So I'll just remind you, Ms. Van Owen, that you're under oath, okay?
Yes, Your Honor.
Great. Thank you. Whenever you're ready, Ms. Moore.
Good afternoon, Professor. Can you please state your first name and spell your last for the record?
Of course. My name is Professor Blake Van Owen, VAN capital OWEN.
And what is your current profession?
I currently work as a professor at Colorado University, Denver, teaching a class in social justice and police practices, as well as being a private investigator.
So, do you have experience in these fields?
Yes, I do.
And where did you receive your education?
I received my education at Ashford University. I got my master's in criminal justice.
And have you used the knowledge that you learned since completing these programs?
Yes, I have. Multiple times.
Oh, sorry. Have you ever been qualified as an expert in court?
Yes, I have. Multiple times.
What fields have you been qualified in?
I have been qualified as an expert in crime scene reconstruction, cell tower data analysis, and general police investigation tactics.
And about how many cases would you say that you have been qualified in?
On over 100.
Your Honor, the defense now requests to admit Blake Van Owen as an expert to render opinions in the fields of crime scene reconstruction, cell tower data analysis, and general police investigation tactics.
Ms. Carrington?
Your Honor, the people maintain that this witness does not have the proper qualifications to render opinions in the field she has been tendered in. However, given the fact that she's been recognized as an expert in other courts, we will not object to her qualifications as an expert and will instead explore her concerning lack of qualifications on cross-examination.
Thank you, Ms. Carrington. Based upon that, I will recognize Ms. Van Owen as an expert in the areas of crime scene reconstruction, cell tower data analysis, and general police investigation tactics, and permit her to give that opinion testimony as such. Thank you both, and go ahead, Ms. Moore.
Thank you, Your Honor. So, Professor Van Owen, why are you here today?
I'm here to testify on behalf of the defense and the defendant, Avery Becker.
And were you involved in the investigation of today's case?
I did review the crime scene reconstruction by Kyle Kuzak and the exhibits prepared by Detective Jordan Markowitz, as well as conducting my own partial investigation.
And you stated that their investigation was rushed. Could you elaborate on this, please?
Yes, I believe they missed some key points that would lead to a reasonable amount of doubt in their case.
And did you conduct any of your own reports in today's case?
Yes, I did.
And did you use this report in today's investigation?
Yes, I did.
Do you keep this report in your regular course of business?
Yes, I do.
And are you the keeper of this record?
I am.
Your Honor, may I now screen share Exhibit 20 with the witness and bench for identification purposes?
You may for that purpose.
Thank you. I will scroll through this so that you can look through it. Do you recognize Exhibit 20, Professor?
Yes, I do.
And what is this exhibit?
This is my expert report that I wrote up for this case.
And is this accurate to the best of your knowledge?
It is, yes.
Your Honor, the defense now moves to admit Exhibit 20 into
Thank you,
evidence.
Thank you, Ms. Moore. And then Ms. Carrington, any objection?
Yes, Your Honor, I would object that this is needlessly cumulative pursuant to Rule 403, as I anticipate this witness is going to talk about everything in this report on the stand today, and therefore it is not necessary for this report to be entered into evidence.
Thank you. And then any response, Ms. Moore?
Yes, Your Honor. Pursuant to Rule number 703, evidence that would be otherwise inadmissible is admissible in expert testimony if the expert used this evidence to assist in their investigation and in their conclusions of this investigation. And this witness has just testified that she did in fact use this in today's investigation. And as to your cumulative objection, also, if you allow me the little bit of leeway, I will not be discussing everything in this case or in this exhibit. She will be discussing a few main points, but she definitely won't be going over everything, as that would take a lot of time.
Thank you, Ms. Moore. And then did you have any further argument, Ms. Carrington?
I have no further argument, Your Honor.
All right, as to this exhibit, because the witness is testifying and she's an expert, I'm going to sustain the objection and not admit this exhibit. She can testify to her opinions as well as her report. I simply don't want to admit this and having it go to the jury because I don't want them to place too much emphasis on the expert's written report as opposed to their assessment of the witness's testimony. And so the exhibit will not be admitted, but you certainly can ask the expert all about it.
Okay, thank you, Your Honor. So what opinions does your report offer for today's case?
Can you take the notebook? Sorry, can you repeat the question?
Of course. So what opinions does your report offer for today's case?
One of the opinions that my report offers is that the prosecution never established that Avery Becker's phone was at Mackenzie Brackman's house that day. And even if they had, that doesn't establish that Avery Becker herself was there, as she had reported the phone missing the day before.
So is it your expert opinion that Avery Becker was not at the crime scene?
That is correct.
And how have you reached this conclusion?
I reached this conclusion by examining the cell tower data and by talking to Avery Becker.
And how likely is it that Avery Becker was near the house at all that day?
It is extremely unlikely.
And do you believe that the prosecution's case is methodologically sound?
No, not in the slightest.
Well, what does methodologically sound mean?
Methodologically sound basically means that the methods and processes that they used to reach their conclusions were logical and made sense. That isn't the case in today's case and with the prosecution.
So if they didn't make sense, what was wrong with the methods that the prosecution used?
There were several things that I found wrong with the prosecution's case. One of them being that Detective Jordan Markowitz never obtained a full and complete cell tower data records for Avery Becker's phone that would allow us to see fully where Avery Becker's phone was all of March 6th. In addition to this, the police accepted screenshots of Alex DeFuente's text that could have very easily been faked and edited.
And can you elaborate more on how the cell tower records were incomplete?
Yes, of course. A cell tower basically covers an area of about 6 mile radius. That's a lot of ground to cover, especially in an urban area such as where Avery Becker lived. And technically, a cell phone doesn't even have to connect to the nearest cell tower. It can connect to a cell tower within a 38-mile radius. That is even more ground to cover. It's not remotely like GPS data and shouldn't be treated as such.
Did you notice any other holes in this investigation?
Yes, I did. One being that the scuff marks. Scuff marks can't be dated. They're not like other pieces of evidence where they can be carbon dated or there's other processes to date them. The scuff marks could have been from 5 years ago or 2 weeks. We just don't know.
And can you please direct your attention to exhibits 1 through 4? I'll pull them up for you. This is exhibit 1, exhibit 2, exhibit 3, and exhibit 4. So does the type of wound on Mr. Brackman tell you anything about his death?
Yes, it does.
Could you explain what it tells you?
Of course. From what I can see, the angle of the knife stabbing was roughly at a 45-degree angle, indicating that Mackenzie Brackman was sitting down while he was stabbed. This completely negates the whole prosecution's case, as I believe a struggle occurred.
And can you now direct your attention to exhibit 5, which has also been admitted into evidence? So did you notice anything specific about the murder weapon pictured here?
Yes, of course. The type of blade this is and the brand of the blade is completely different from the knife block in the kitchen and any of the knives in the assorted knife drawer. It is extremely unlikely that the knife itself came from Mackenzie Brackman's house.
And I'll stop screen sharing. What does this mean in today's case?
This indicates premeditated murder, which Avery Becker is not being charged with today.
So, in your expert opinion, is there adequate evidence to prove for certainty that Avery Becker is guilty of these crimes?
Absolutely not.
Thank you, Professor. No further questions, Your Honor.
Thank you, Ms. Moore. And then cross-examination whenever you're ready, Ms. Carrington.
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
You may, thank you.
Good afternoon, Professor Van Owen. Now, you say there's no evidence of a struggle at the victim's house. Am I right?
That is correct.
There were scuff marks found on the floor, weren't there?
Scuff marks don't indicate a struggle.
That wasn't my question. Yes, there were scuff marks found on the ground.
While they were found, yes, they don't indicate a struggle in the slightest.
And there was a broken plate found at the scene.
Yes, but this also doesn't indicate a struggle.
Once again, that wasn't my question. Yes, there was a broken plate found at the scene.
Yes, which doesn't indicate a struggle.
And there was also a chair found tipped over at the scene.
Yes, which doesn't indicate a struggle.
And based on your analysis, you agree a burglary occurred, don't you?
Yes.
And you agree that Mr. Brackman was killed during the course of that burglary?
Yes, that fact is not in dispute.
Now, I'd like to talk about some of the things you agree with Ms. Kuzak on. You agree that the description of the blood drops and cast off is consistent with the victim moving along the hallway with the knife lodged in his back. Is that right?
I never saw the pictures. They were corrupted, which is just really shabby work on the police's part.
Have you ever said the words, the description of the blood droplets and cast off is consistent with the victim moving towards the front door with the knife lodged in his back?
The description from the detectives and Kyle Kuzak's memory, I don't trust it in the slightest, but perhaps, yes, I did say that.
And you agree that when the victim, that the cast off is consistent with the victim pulling the knife out of his own back?
I believe so.
And you believe that when, excuse me, and you agree that when the victim pulled the knife out of his back, he would have bled to death rapidly?
I believe that is how anatomy works.
Is that a yes to my question?
I did say yes.
And where we really disagree is over who committed this crime. Is that fair to say?
I suppose, yes.
You agree that Avery Becker was absent from school on March 6, 2020, don't you?
I don't believe that fact is in dispute, but yes, I do agree.
And you agree that the cell tower reports place Avery Becker's phone near the victim's residence?
It may place Avery's phone there, but it's not like GPS.
So that's a yes to my question. It places the phone there.
It places the phone in the vicinity within 6 miles of Brackman's house.
And you agree that Avery Becker matches the height and build of the intruder on the Ring doorbell videos.
I believe that a lot of people match the height and build of the figure in the Ring doorbell cameras.
Is that a yes to my question? Avery Becker matches the height and build of the intruder in the Ring doorbell videos.
I suppose, but so do a lot of people.
Now, you think of yourself as a check on the power of police, don't you?
I believe that I point out holes where the prosecution fails to see. So I suppose yes.
And you've made a living off of revealing where the police have dropped the ball?
Yes, because I have to be hired independently. All of the prosecution experts are usually...
That wasn't my question. Yes, you've made a living.
Cutting off my witness. She's just trying to explain to the best of her knowledge so the jury can have a better understanding.
I'm going to overrule the objection. I think that Ms. Carrington directed the witness to answer in a yes or no manner. And so just make sure you don't cut the witness off.
Yes, Your Honor, I apologize. So that's a yes to my question. You've made a living revealing where the police have dropped the ball.
I suppose yes.
And you worked as a police officer for 9 months back in 2005, isn't that right?
Yes, I did.
And you never mentioned investigating burglaries or homicides in that role, did you?
While I may not have gotten experience from working there, I did get experience from obtaining my master's in criminal justice.
That wasn't my question. That wasn't my question. My question to you was, when you worked as a police officer, you never mentioned investigating burglaries or homicides. Isn't that right?
No, I don't believe so.
And you've been a private investigator and a professor for about 6 years, right?
I guess that sounds about right. Gosh, it's been a long time.
And in that time, you've only testified for the defense and never for the prosecution on any of these matters. Is that right?
Yes, but there's a specific reason for that.
Now, excuse me. You would agree that there were a lot of different law enforcement members involved in this crime, wouldn't you?
I'm not quite sure what you mean.
Well, you would agree that there were uniformed officers, a forensics team, Kyle Kuzak, and Detective Markowitz all involved?
Yes, I suppose.
Your Honor, compound question.
Ms. Carrington?
Yes, Your Honor. If the witness is confused by the question, I can definitely break it up for her.
Well, you said they were all involved, and so that means that I don't know if that's really compound, so she can either say, yes, they were all involved, or no, they weren't. So I'll overrule the objection.
Thank you, Your Honor.
You're welcome.
So that's a yes. A lot of different officers were involved in this crime.
Yes.
And you would agree that with all these officers, hundreds of hours were spent investigating.
I don't know. They never submitted a log sheet or anything.
Now, when you're rushed, you miss things. Your words, right?
Yes.
And by the way, you charge the defense $225 per hour for any investigation work. Is that right?
Yes, but that is because I am hired privately outside of this courtroom. The prosecution uses experts from law enforcement personnel, so they don't have to pay for their experts.
So that's a yes to my question. That's what you charge.
Yes, that is true.
And you charge $450 for court deposition and testimony.
That is also correct.
So far, you've charged just under $7,000 for your investigation. Is that right?
Roughly.
And you anticipate charging at least another $1,000 more for your testimony here today?
Depending how long we take, yes.
Your Honor, at this time, I have no further questions for the witness. However, pursuant to Rule 201, I ask the court take judicial notice that $7,000 divided by $225 per hour is approximately 31.1 hours spent working on this case.
And then any objection to me taking judicial notice of that, Ms. Moore?
No, Your Honor.
All right, and so ladies and gentlemen of the jury, I do take judicial notice of that mathematical calculation. However, I instruct you that it may or may not be accepted as a notice fact that is conclusive for purposes of your deliberations, given the nature of this case. And so with that, thank you, Ms. Carrington. And do you have further redirect, or redirect at all, I should say, Ms. Moore?
Yes, Your Honor.
Great.
Professor, why are you paid in today's case?
I'm being paid because I am hired as a private investigator outside of the investigation done by the police. All the experts hired by the prosecution and all the experts that the prosecution uses are law enforcement personnel. They don't have to go searching for people to testify for them.
And would the fact that you're being paid change your opinions on this case in any way?
No, absolutely not.
Thank you, Your Honor. No further questions.
Thank you, Ms. Moore. And then any recross based on that, Ms. Carrington?
No recross, Your Honor.
Great. Thank you, Ms. Van Owen. You may step down. And so with that, I will ask Mr. Loya if the defense wishes to call any additional witnesses.
We call Ms. Avery Becker to the stand.
Thank you. Good afternoon, Ms. Becker.
Good afternoon.
I'll just remind you that you're under oath, all right?
Yes, Your Honor.
Great. Thank you. Whenever you're ready, Mr. Loya.
Thank you. Good afternoon, Ms. Becker. Please state your name and spell your last name for the record.
Hello, my name is Avery Becker, Becker.
Ms. Becker, have you attended school or had a job in the past?
Yes, last year I was a senior at Colorado High School, but I know it as CHS.
Do you participate in any extracurricular activities?
As a matter of fact, I did. All 4 years of high school, I was on the mock trial team.
How was that?
It was amazing. I was a natural. I mean, at first, I just joined to spend time with my best friend, but I grew a deep liking for this activity. It was so much fun. I'm a natural. I won a ton of awards. It was amazing.
Was there any problems in mock trial?
Well, there were a few. You see, my coach, Coach Brackman, and I didn't really see eye to eye. We had 2 different ways of doing things.
Did this create any more problems with Mr. Brackman?
Yes, we had a lot of arguments and disputes over the way we did things.
Did this lead to any altercations, incidents?
Yeah, right before regionals, he demoted me because I was unprepared, but I like to make things up on the fly. And then after regionals, he was grilling me because I got all these amazing awards, and I got frustrated and I wrote on his Porsche, and it was supposed to be a dry erase marker, but I later found out it was a permanent marker.
Ms. Becker, do you regret your actions?
Deeply. If I could take them back, I would. And I tried to apologize over and over again.
Did you do anything to apologize?
Yes, I tried to reach Brackman at his local law firm, but he just refused to see me. And then I sent him a text, but he never responded. I really did try to apologize.
And before this incident, was there any other case that might have led you to be demoted, kicked off the team?
Well, Brackman said I was unprepared, and so he moved me to B team right before regionals.
And did you do anything to get back on A team?
I didn't do anything personally, but my best friend Taylor Perkins said that the team needed me and she quit.
And did Taylor do this because she was your friend?
Based off my personal knowledge, no. Like she said, the team needed me.
Ms. Becker, do you know why you're in court today?
Yeah, I'm being unfairly accused of murdering Mr. Brackman. The prosecution's doing the same thing Mr. Brackman used to do to me all the time.
And Ms. Becker, do you know where Mr. Brackman even resides?
No, I've never been to his house. Our relationship was strictly professional.
Ms. Becker, could you tell me what you were doing on March 6, 2020?
March 6th. Oh, yes. I spent the entire day with my best friend, Taylor Perkins. I had lost my phone the previous day, and she was a great friend. She offered to help me find it.
Where'd you go look for the phone?
Well, we went to 2 main places. We went to the mall and the Fry Shack.
And how'd you lose your phone?
Well, the previous night, we were at the Fry Shack hanging out, and then a whole bunch of the mock trial team showed up, and I got frustrated when they were talking about Brackman, and I stormed off. I don't remember grabbing my phone, but I know Alex Cifuentes was near it when I stormed off.
Do you happen to know Alex Fuentes?
Sadly, yes.
And why would you say that?
Miss Cifuentes and I don't really get along. She may claim we're best friends, but I'm not really friends with her. I think she's a brown noser, and We just don't get along that well.
So to clarify, you weren't close to Alex Fuentes?
No, definitely not.
And would have Alex gained anything if you were kicked off the team?
Yes, because I was the best on the team, I always got the best roles, the closings, the experts, and if I was gone, Alex was next in line to get those roles.
And did you ever receive any text from Alex Fuentes?
No, like I said, I don't really get along with Alex Fuentes. I don't really talk to her much.
Moving on, Ms. Becker, do you know who Blair Rollins is?
Yes, I believe it's one of Alex Fuentes' close friends.
Okay. And Ms. Becker, do you gain anything from murdering Mr. Brackman?
No, state was already canceled due to COVID. There was nothing I could gain.
And would getting kicked off the team ever push you to do such a crime?
Of course not.
And Ms. Becker, did you go to Mr. Brackman's house the night of the murder?
No, I don't even know where Mr. Brackman lived.
And did you break into his house?
No, I don't know where he lived.
And Ms. Becker, lastly, did you murder Mr. Brackman?
Of course not.
No further questions, Your Honor.
Thank you, Mr. Loya, and then Ms. Feeney, whenever you are ready with cross-examination.
Yes, Your Honor. Before I begin, may I inquire as to how much time is remaining?
You may.
The prosecution has 7 minutes and 18 seconds remaining.
Before I begin, can Your Honor see and hear me all right?
I can, thank you.
Ms. Becker, first I'd like to talk about something you said on direct examination. You claim that you regret your relationship with Mr. Brackman. Did I get that right?
I regret riding on his car.
So is that a yes or a no to my question?
My relationship with Mr. Brackman was rocky, and I can't really help that, but I did say I regret riding on his vehicle.
However, have you ever said that he had a massive ego?
Oh, he did have a massive ego, definitely.
You even went so far as to call Mr. Brackman a joke, didn't you?
Yeah.
And just to be clear, you wrote this all in your affidavit after Mr. Brackman was murdered. Isn't that right?
Yes.
Now, let's talk about motive. It's fair to say that you and Mr. Brackman never had the best relationship, right?
As I previously said on direct examination, we didn't get along. We saw things different ways.
You fought at almost every practice, didn't you?
We argued very frequently, yes.
That is, until you were kicked off the team 3 days before Mr. Brackman was murdered, isn't that right?
Well, we never argued after that. I never saw him after that.
You were kicked off the team for vandalizing his Porsche with a permanent marker, am I right?
May I speak?
You may.
The opposing counsel is testifying as they're saying that it was a vandalization, even though vandalizing is a serious crime, and there was no, what is it called? Crimes being pushed to say it was vandalization. It was just a mere accident, an incident, not vandalization.
Thank you, Mr. Loya. Ms. Feeney, as to you using the term vandalism at this point?
Yes, Your Honor. It is understood in today's case that Ms. Becker wrote on Mr. Brackman's Porsche with a permanent marker, Worst Attorney Award, which constitutes vandalism. Whether or not the crime was ever charged is not relevant.
So I'm going to sustain the objection. Just have you can talk about the incident, ask about the incident, just avoid using the term vandalism. In part, Ms. Fuentes described it as a vandalism. I don't think there's any such, unless you can point to a specific part in Ms. Becker's affidavit. Ms. Becker herself didn't refer to it that way.
Yes, Your Honor. Ms. Becker, you were kicked off the team because you wrote in permanent marker on Mr. Brackman's Porsche, correct?
Yes, but it was supposed to be a dry erase marker. I was standing at the dry erase board when I stormed out.
Is that a yes or no to my question? You wrote on his car with a permanent marker.
As I've previously stated, yes.
Af- Getting kicked off the team made you angry, didn't it?
I was upset. I love mock trial. It really hurt that I was kicked off, and I tried everything to get back on.
That's a yes to my question?
Yes.
So angry, in fact, that you said that night that you would get back at Brackman if it was the last thing you did, in your words?
I did say that, but I was just upset and angry. People say things when they're upset.
Now, let's talk about the messages. As you said on direct examination, you attempted to get back on the mock trial team, correct?
Yes.
At this time, may I publish Exhibit 14 to the jury?
You may. Thank you.
If my trial technician would, there we go. Ms. Becker, that is your name and the contact information at the top of the screen, correct?
Forgive me, you cut out. Can you restate your question?
Of course. Your name is in the contact information at the top of the screen, correct?
That's what it says.
And in these texts, the person labeled as Avery Becker is attempting to get back on the mock trial team, yes or no?
Yes, but I never sent these messages.
Thank you. The exhibit is no longer needed. You claim to have lost your phone the day before, am I right?
I did lose my phone.
But of all the people who were supposedly there at the Fry Shack, Ms. Perkins is the only one to testify that you lost your phone that day, isn't that right?
Yes, but I don't see how that means anything.
Ms. Perkins is also your best friend, isn't she?
Well, yeah, but so what?
Now, let's talk about the map. May I have permission to publish Exhibit 16 to the jury?
You may, Ms. Finney. Thank you.
You heard Detective Markowitz talk about this map earlier today, correct?
Yes, but I don't really understand it.
Well, let's try to make some sense of it. If my trial technician would please circle the location marked as Ms. Becker's house. Ms. Becker, your house is in the same area as your phone was at 1247, isn't that correct?
Well, I assume that's what this map is saying, but
Looking
I'm
up-
not sure.
Mr. Loya?
Lack of personal knowledge. My witness has no credible knowledge of what this exhibit might behold or have any knowledge of what it has.
Ms. Feeney?
Yes, Your Honor. This is, as the exhibit is being shown and the witness is able to view it at the moment, foundation has been laid as to how she can testify as to what is on this map as she can see it on the screen.
All right, so I'm going to overrule the objection. If she's able to testify from it and appears to have knowledge of it, we can continue. If she didn't, sounds like she doesn't, then you can raise your objection, Mr. Loya. But I think she had started to testify, so I didn't really have an indication that she wasn't able to at least identify it. So go ahead and proceed from this point. We may run into that issue, though.
Yes, Your Honor. Ms. Becker, your house is in the red area where your phone was at 1247, isn't that right?
Well, what's marked as my house is in the red area, but I don't know if my phone was there. I lost it, and I don't really understand this map. I'm not an expert. I'm sorry.
Thank you. The exhibit is no longer needed. Let's talk about some other points of the prosecution's investigation. We can agree that you skipped school on March 6, 2020, correct?
Yes, but I was with Taylor Perkins all day. We went to go look for my missing phone. I assumed.
Objection, Your Honor. May I be heard?
You may.
I object non-responsive. I asked a clearly framed yes or no question, specifically that if we can agree that Ms. Becker skipped school on March 6th of 2020. The witness has gone far beyond the scope of my question. At this time, I would like to remind the court that this is a timed competition. If the witness feels that further explanation is necessary, she may do so upon her own time on redirect.
Thank you, Ms. Feeney. Any response, Mr. Loya?
No, Your Honor.
Okay, so I will sustain the objection. Ms. Becker, I'll just remind you, if it's a yes or no question, give the shortest answer that you can. Specifically, if you can answer yes or no, answer yes or no. Your attorney will have an opportunity on redirect to ask for any clarification or additional information he may want to ask based upon questions asked by Ms. Feeney. So if you want to go ahead and re-ask your question, and I'll instruct the witness to answer with a yes or no.
At this time, I move to strike any testimony beyond yes.
So the jury is instructed to disregard any of the statement beyond the yes.
We also agree that you match the height and build of the person in the ring videos, correct?
Well, yes, but I'm not sure.
Have you ever stated that you match the height and build of the person in the ring videos?
Vaguely, but I'm no expert.
Thank you, Your Honor. I have no further questions at this time.
Thank you, Ms. Feeney. And then any redirect, Mr. Loya?
Yes, Your Honor. Ms. Becker, did you say that writing that you did not know that the marker was permanent?
No, I had no clue. I was at the whiteboard at the moment I stormed out. I thought I had a dry erase marker.
And Ms. Becker, what was your reason for your absence on March 6, 2020?
I was with my best friend, Taylor Perkins. We were looking for my missing phone.
No further questions, Your Honor.
Anything based on that, Ms. Feeney?
Yes, Your Honor, briefly. First, may I inquire as to how much time I have remaining?
You may, thank you.
The prosecution has 47 seconds remaining.
Ms. Becker, of all the people who supposedly saw you at the mall on March 6, 2020, Ms. Perkins was the only person to testify that you were in fact there that day, yes or no?
Well, she's the only one in court to testify, yes.
Thank you, Your Honor. I have no further questions.
Thank you, Ms. Feeney. Thank you, and thank you, Ms. Becker. You may step down.
Thank you.
And then, Mr. Loya, does the defense have any other witnesses?
No, I do not. Your Honor.
Great. All right. So with that, the defense has rested. I have now instructed the jury with respect to the instructions that will guide their deliberations in this case. And with that, I will ask Ms. Buchan if the prosecution wishes to give a closing argument.
Yes, Your Honor, but before I begin, I have two requests.
Go for it.
First, as a reminder, my co-counsel reserved time for rebuttal at the end of my closing argument.
Thank you.
And my second request is that during the course of my closing argument, my trial technician be allowed to display pieces of evidence I'll be discussing, only ones that we've admitted into evidence and that we've sought to publish. In particular, I'll be discussing Exhibit 16 and Exhibit 14, and I ask permission for those to be published for the jury during the course of my closing argument. And I also ask that jury instructions 7, 8, and 9 also be allowed to be displayed to the jury during the course of my closing argument, as I will also be discussing those.
Thank you, Ms. Buchan. So purposes of closing argument, your trial assistant may display any admitted exhibit as well as any jury instruction that I have tendered to the jury. You do not need to ask leave of the court to do that so that it doesn't interrupt your closing. You have standing permission for that purpose.
Yes, Your Honor. May it please the court.
It may, thank you.
You can hide your face behind a mask, but you cannot hide the truth. And the truth is in the map, the messages, and the motive. The prosecution and defense agree on a lot today. We all agree that a burglary happened. We all agree that during said burglary, Mackenzie Brackman was killed. And we all agree that a person matching the size and build of the defendant is the one who committed these crimes. The only dispute today is over who wore that mask. The members of the jury, that mask cannot hide the truth because the truth is in the map, the motive, and the messages. The map. Detective Markowitz showed you with Exhibit 16 the route taken from Avery Becker's house to the home of the victim. The detective explained how cell towers tracked Avery along this route, placing her at the scene of the crime during the burglary and murder. The messages. You saw the text messages sent between Avery Becker and Alex Cifuentes. Texts that were highlighting the bitter truth of Avery Becker's intent. Let's hear her text again. Well, if he's still upset about what I did to his car, then he's going to be really upset when he sees what I do to his house. I'm going to wait till he's at work, then break in and trash it. That'll show him. And that's exactly what Avery Becker did. She waited until she thought Mr. Brackman was at work, broke in with the intent to do damage, and then stabbed Mr. Brackman with the very knife he used to defend himself. The motive. As we heard time and time again today, Avery Becker and Mr. Brackman have had a history of petty fights and low blows, escalating in the vandalization of his 1986 Porsche. Failed attempt after failed attempt to get herself back on the team made Avery Becker angrier than she'd ever been before. So she put on the one thing she thought would hide herself, a mask, and made a promise that she would get back at Brackman if it's the last thing she did. As the prosecution, we've charged the defendant with 2 crimes, murder in the first degree and second-degree burglary. In order to understand murder in the first degree, it's helpful to talk about second-degree burglary. So let's do that. Jury Instruction 8, which is displayed for you now, describes the crime of second-degree murder, of second-degree burglary. And Jury Instruction 9 defines the crime of criminal mischief, the very crime the defendant intended to commit when she entered the residence. Now, when you put it all together, we've proved that the defendant committed second-degree burglary because she entered Mr. Brackman's residence without permission and with the intent to cause damage to his property. So it doesn't matter whether the crime of criminal mischief was committed. Simply because the defendant is guilty of second-degree burglary the moment she stepped into Mr. Brackman's house. So now let's talk about murder. Jury Instruction 7 describes the elements of murder in the first degree. It says Avery Becker committed this crime if Mackenzie Brackman died as a result of the burglary on March 6th. Members of the jury, the defense's own theory is that Mackenzie Brackman died as a result on the home invasion of March 6th. So the only question left is who wore that mask? But we've already answered that question for you. You know it was Avery Becker behind that mask because we showed you the map. We showed you the messages, and we showed you the motive. Find the defendant, Avery Becker, guilty. Thank you.
Thank you, Ms. Buchan. And then with that, Ms. Moore, does the defense wish to give a closing argument?
Yes, Your Honor. May it please the court?
It may. Thank you.
Your Honor, opposing counsel, and members of the jury. As Clement Stone once said, truth will always be truth, regardless of lack of understanding, disbelief, or ignorance. And in today's case, the truth has shown through. On March 6th of 2020, Mackenzie Brackman was found dead in the doorway of his home. Mackenzie Brackman was the head coach of the Colorado High School mock trial team, volunteering his time. My client and the defendant in today's case is Avery Becker. Avery Becker has been wrongfully accused of committing these crimes and is being charged with murder in the first degree and burglary in the second. Ladies and gentlemen of the jury, today's case is about an expert seeing one possible suspect and closing all other options. Today, the defense called Avery Becker herself to the stand, who told you that she was not near Mackenzie Brackman's home on March 6th. She was looking for her lost phone all day. She also testified that she was never in possession of her phone that day, and that, in fact, she doesn't know where he lived at all. This leaves the prosecution expert witnesses' main pieces of evidence completely unreliable and pretty much meaningless. We then called Taylor Perkins to the stand, who told you that she was with Avery Becker all day on the day of March 6th. She also told you that Alex Cifuentes, the prosecution witness who claims to have received text messages from Avery Becker about the murder, didn't get along with Avery at all. Last, we called Blake Van Owen to the stand, a private investigator and expert in police practices. We asked you to listen closely when she explained to you that the prosecution's investigation was rushed. And when you're rushed, you miss things. She also told you that Jordan Markowitz and Kyle Kuzak chose one suspect based on 2 screenshots of text messages they never even saw alone. And she continued to show you that all of their claims are assumptions. In fact, on the cross-examination of Markowitz, you heard her say that she assumed that Avery Becker disposed of a mask, which she never collected. The prosecution in today's case also called witnesses. The first, Detective Markowitz, an expert who has provided us with absolutely no credentials in today's case. This leaves us to what? Trust her word? This becomes hard when Detective Markowitz presents opinion after opinion with no real evidence to prove it as true. We asked you to listen closely to the cross-examination of Detective Markowitz when she told you that she has no fingerprints, no footprints, and no DNA evidence at all. She also told you that in the ring videos from March 6th, you cannot see the assailant's face in any way, leaving any evidence against Avery Becker all based on a guess. In today's case, the prosecution has the burden of proof, and they were required to prove each and every element beyond a reasonable doubt. As the defense, we do not have this burden, but we have still shown you that Avery Becker is in fact innocent. But more than that, what we have shown you is that the burden of proof in today's case was not met. And with that, the case is simple. The simple truth is, there is not adequate evidence to prove Avery Becker guilty of these crimes, and they could have been committed by pretty much anyone. The defense does not refute the fact that murder in the first degree and burglary in the second degree occurred. But what we do refute in confidence is that it was Avery Becker who committed these crimes. The prosecution just went with the easiest answer. And as we have seen today, this is not the right answer. Number 6 states that the credibility of an expert's testimony is to be considered as that of any other witness, and that the weight you give to that testimony is entirely your decision. At the end of this case, the defense asks that you will apply fact to law and deliver the only plausible verdict of not guilty on all charges. Thank you.
Thank you, Ms. Moore. And then Ms. Buchan, do you wish to use your reserve time for rebuttal?
Yes, Your Honor. Before I begin, may I inquire as to how much time I have remaining?
You may, thanks.
You have 1 minute and 17 seconds remaining.
Opposing counsel called our investigation rushed. They called it flawed. But I'll have you know that as the prosecution, we've displayed 17 different exhibits in today's case. All while Professor Van Owen, the person who's supposed to check the prosecution, conducted a mere 31-hour investigation in today's case. But I do agree with the defense. The truth did prevail. The truth did show through. However, the truth is in the map, it's in the messages, and it's in the motive. What's critical to hear today is that Taylor Perkins admitted to the fact that Avery Becker texted Alex Fuentes asking for help to get back on the mock trial team. Your Honor, and members of the jury, opposing counsel tried to show you the mantra of innocence, that it was Avery Becker who was an innocent child. But they're merely trying to hide the truth from you that is displayed in the map, the messages, and the motive. So I ask you, come back with the only just verdict of guilty. Thank you.
Thank you, Ms. Buchan. With that, we will send our jury out to deliberate, which in this case is to finish their scoring. So good job, first of all, to the team. We'll have some comments for you. We're going to go ahead and do some comments with the last round, in large part, just so you can see and know who your scoring judges were. So we'll let them do that, and then I'll let everybody turn their cameras back on. So if the scoring judges will go ahead and finish their score sheets and then submit them, and then turn your video back on once you've submitted your score sheet. And I do have yours, Mr. Wilmore, so you're good. And I have yours, Ms. Starrett, so you're good. and I failed to unmute myself. I have Miss Tate's score sheet now, so everybody can unmute, turn your videos on if you want. So first of all, it's good to see everyone's face for the first time of the entire tournament. I've seen a bunch of names, but haven't seen any of you in person. I recognize some of your names from various years past. That may be you, that may be siblings, that may be something else. But first of all, we're going to just give you a few comments. I think you know we're trying to keep it to about 3 minutes. I'll have your scoring judges tell you who they are, why they're here, what they do, and then any feedback they have. I just want to say generally, good job, everyone. I thought you all handled objections, rulings, all of those things very well. And I thought all of your witnesses did a good job keeping things interesting, and in your examinations were all good. It's always a joy to preside over your rounds. You're always prepared and know the rules and have worked really hard. And so with that, my name's Lance Timbreza. I'm a district court judge in the 21st Judicial District, which is, you likely know, as Grand Junction. And so preside over cases like the case that you tried today. And so with that, good job, everyone. And then let me start with Mr. Wilmore. Go ahead, Mr. Wilmore.
Thank you, Judge. So yeah, my name is Michael Wilmore. I'm a trial attorney primarily focused on criminal defense work. I was at the Grand Junction Public Defender's Office for about 3 years, and I've been in private practice at a law firm called Calamia Gosha for the past year, and we're primarily based in Glenwood and Aspen, and I take cases all over the Western Slope. I've done a few actual jury trials with Judge Timbreza, including a very fun one that went until about 11 p.m. on a Friday. So I'm sure he remembers that experience. But yeah, overall, yeah, you guys are great at this, like way higher caliber than what I was expecting coming in to judge a high school mock trial tournament. I hope a lot of you continue on with either mock trial or potentially legal careers in the future, because I think all of you would be great assets to various states' bar associations. In general, I'll just say like some things that I thought you all did really well. Again, I saw one of these teams before, but it's like you guys are great at the Zoom stuff. Even though I know the defense had a bit of a technical issue, you handled that really well, and you guys are better than 95 to 98% of attorneys, I think, at the Zoom stuff already. It's very good, and on top of it, you guys are on top of all that. It's great. In general, like the one thing I'll say to all of you is if you continue doing this, whether it's high school, college, law school, or doing trial work as a profession in the future, always remember that like it's super easy to get really uptight with like the rules and like what you're doing and sticking to your script. But at the end of the day, you're just talking to people, right? You're talking to jurors, you're talking to witnesses, and you're coming after them. And at the end of the day, it's like a performance-based thing. It's acting more so than memorizing rules and things like that. So some of the best feedback I ever got for actual trial practice and mock trial was during law school, which was to watch really good interviews with people and take notes from how the interviewer handled like a really good interview, whether it's like a late night thing with like Stephen Colbert or like just a solid interview from a journalist. And that really helped me out a lot when examining witnesses. But yeah, you all did great. It was awesome to watch you guys, and I know you'll be successful in whatever you do in the future.
Thank you, Mr. Wilmore. And he's right. I think we were in trial till 11:30, and imagine we started at 9 in the morning. So that was a long day. Ms. Starrett, how about we go to you?
Hi, everyone. I'm Emily. I did mock trial all 4 years of high school. I was co-captain for, I think, like 3. So it seems like not too long ago, I was doing this exact same thing. Both sides did really, really well. It was very obvious. You guys were very prepared. I know how stressful and how time consuming this can be. So it was definitely apparent that you guys put in a lot of hard work. I really liked how, even though we were kind of in this Zoom setting, you guys kept a lot of the like same courtroom procedures, like publishing exhibits to the jury and standing up to do like questions and openings and closings and identifying the defendant. I thought it was it made it a lot more interesting to watch. So good job overall. You guys did really well.
Thank you. And then last but not least at all, Miss Tate.
Hi, my name is Francesca Tate. I'm an associate attorney over at Holland Evans in Denver.
My practice primarily involves civil litigation defense. I've been practicing around 3 years. I didn't do mock trial in high school, so it was really interesting watching you guys today. I thought you all did a really good job. The Zoom environment isn't as far-fetched as it is today. I actually did my first bench trial over Zoom last month, so you guys did great considering, especially with the technology. Way ahead of the other lawyers today on Zoom. Little bit of feedback for you guys. First of all, I thought that with the objections, you guys could have exercised a little bit more on your beyond scope of direct examination objections for cross-examination. That being said, with cross-examination, you guys were very well prepared, but the one thing with cross-examining a witness is a lot of your cross comes from what you hear on direct examination. So I guess in the future, next time, I just recommend more focusing on what has been presented on direct examination and tailoring your plan cross-examination based on that. As well as on the other side, when you're the person that just gave the direct examination, making those objections when the cross is going beyond direct examination. I thought with the plaintiff, or excuse me, with the prosecution, I don't know the rule in terms of if you get to actually choose the order of your witnesses, but I thought that your case could have been presented a little bit better if you changed the order of your witnesses. I thought maybe starting with an expert may have been a little bit more persuasive just from someone who's sitting in the audience watching. In regard to the defense, I thought that in your closing argument, I would have emphasized the burden of proof a little bit more. Beyond a reasonable doubt is really high standard, especially in criminal case. And I thought it just could have been harpened a little bit more, that the prosecution did not meet their burden of proof. You guys did a great job. I was really impressed. Other than that, I don't think I have really anything further.
Thank you, Ms. Tate. So with that, good job, everyone. I hope that if you're competing next year in this tournament for purposes in the regional, I know that there's still state ahead for 2 teams in this competition, but I hope if you're not a senior this year that you do it again next year and then we get to see you in person here in Grand Junction in the courtroom. That'll be nice to be in person again. With that, I did let your coaches know, and I'm sure they passed the message along that they'll receive the overall tournament results by the 5 o'clock today. We had a round that started about 45 minutes late with some technical issues, but they have now completed. But there is still one more round out, so it'll take a little bit of time to get scores. You should all be very proud of the work you've done doing this electronically. I did my first in-person trial. It wasn't a jury, it was a bench trial this week. It was very strange to be in person with masks on in the courtroom. But you all handled Zoom quite well, and I enjoyed all of it. And so with that, good job, good competition, and have a good rest of your weekend, everyone, all right?
Thank you.
Thank you.
Thank you.
Thank you.
Thank you so much.